Good morning, ladies and gentlemen, both here in Geneva on Zoom as well as on the YouTube stream. I'm Wolfmar Evert. I'm the Secretary of the TRIPS Council, and I have the honor of being your moderator this morning. Now, let me remind you that this is a virtual symposium on 25 years of the TRIPS agreement. This is intended to provide an informal forum to share some of the practical lessons from 25 years experience working with TRIPS. This event is interpreted into the three official WTO languages. You will find the interpretation symbol at the bottom of the screen in your Zoom screen, and you can choose the relevant language. We are also interested in hearing your questions, so please use the Q&A function here in Zoom, and those who are watching the YouTube stream, you can send us your questions to ipd@wto.org. So with this, I'm very happy to share that Deputy Director General Yi has agreed to open to say a couple of opening words and opening remarks, which he has recorded earlier. And so I'm handing the floor now to DDG Yi to open this virtual symposium. There seems to be a technical problem. I invite my colleagues now to stream the opening remarks of DDG Yi, please.
Excellencies, ladies and gentlemen, today we are celebrating the 25 years since the WTO TRIPS agreement came into force. It created a remarkable new international framework, forming essential legal infrastructure for the knowledge economy that has emerged and taken shape since then. The TRIPS agreement forms one of the central columns of the WTO's architecture. It remains the most comprehensive multilateral instrument on intellectual property. Today, with the WTO agreements on trade in goods and trade in services, the TRIPS agreement and its effective implementation by countries across the globe has underpinned extraordinary trade and economic growth over the last 25 years, not only in scale, but in its knowledge component and its diversity. Proof of this is the way that today we can benefit from the countless international transactions in intellectual property rights that enable us ever more seamlessly to reach each other. The very camera in front of me is a bundle of IP rights sourced from countless technology providers, as is the screen you are using to view this event. And the telecom and the business services that stream this video to your screen are themselves enabled by international trade in IP rights. Intellectual property is embedded in our lives. It is an important component of global value chains and forms an integral part of the embedded value even in the tangible traded goods. WTO research shows that, for example, 91% of the price of a jacket is linked to intangible assets, of which intellectual property rights are an important component. Over the last 25 years, trade in goods and services with high intellectual property content has grown exponentially. Statistics from the International Monetary Fund show that payments for the use of intellectual property rights increased by 1,053% from $38 billion in 1995 to $438 billion in 2019. This increase greatly surpasses the rate of growth in conventional trade in goods and thereby illustrates the success of trade in IP itself. The increasing intellectual property component of trade, even of trade in goods, could prompt us to look behind the traditional balance of trade figures. We increasingly need to take into account the bundles of IP licenses and royalty payments that form part of value chains so as to get the full measure of who is benefiting from trade. The experience with TRIPS has also given us salient reminders that trade rules and IP standards do not exist in isolation from wider public policy concerns. Nowhere is this more evident than in the field of public health. This was a compelling issue 20 years ago, leading WTO members joining together to adopt the landmark Doha Declaration on the TRIPS Agreement and public health. And it is, of course, an urgent and challenging issue for us all today. The TRIPS Agreement was the first multilateral agreement in the entire WTO package of law to be amended, and this was on the proposal of the African Group to address public health concerns. The amendment created an additional legal pathway for access to affordable generic medicines for countries in greatest need. And the Doha Declaration still forms a sound basis for policy coherence and practical cooperation, now evident in the response to COVID-19. As we mark the 25th anniversary of the entry into force of the TRIPS Agreement, I invite you to take account of the progress we have made so far. We should acknowledge the remarkable possibilities this opened for creators, innovators, and companies across the globe, at a time when the knowledge component of development is recognized as being essential in today's economy. It is time to recognize the enormous efforts undertaken, especially by developing countries over the past 25 years, to build, modernize, and reform the legislative, administrative, and enforcement foundations of their IP systems. Along this unprecedented worldwide overhaul of the infrastructure for the knowledge economy, we have seen remarkable growth in the human capital, in understanding of IP law and policy right across our membership. This rising tide of development has been strong and steady, and yet has been so foundational, there's a risk that it is now simply taken for granted. For the WTO, it is a chance to reflect on the remarkable range and impact of the technical cooperation and collaboration that has underpinned TRIPS implementation over these years, through a host of multilateral, regional, and bilateral programs, and especially through cooperation with WIPO and other multilateral partners. Next month, in fact, marks the 25th anniversary of our bilateral agreement with WIPO, which still anchors and guides this indispensable and fruitful partnership. We should also recognize that the system is not perfect. There is plenty more work that can and should be done. History shows us that situations like the COVID-19 pandemic make us leap forward and adapt, and that having clear rules enhances international cooperation. I would like to invite you all to join this opportunity for reflection and forward thinking. There's much to learn from the past 25 years. Let us make the most of our experience to face up to continuing global challenges and respond to them in a balanced, sustainable, inclusive, and effective manner. This symposium is just the opening of a series of events aimed at refreshing and enlivening an essential conversation, and we invite you to join us on this journey. Finally, welcome to the virtual symposium on the 25th anniversary of the TRIPS Agreement. I thank you.
Thank you very much, Deputy Director General Yi, for having taken the time to record these opening remarks for this virtual symposium. I think we may have now overcome the initial technical difficulties that I think we faced at the beginning, so I hope we will have a smooth ride from now on. Let me move to the first part of this program. We are grateful to be joined this morning by two people who will be able to give us a first-hand experience and account of what it is like to participate in the running of the TRIPS agreement. And we thought it would be best if we start this day with reflections of chairs of the TRIPS Council. So I'm very happy to be joined this morning, and I would invite the two speakers to activate their video by Mr. Stuart Harbinson, who is a former permanent representative of Hong Kong, China, and also a former Secretariat official. He is now a trade consultant, but he was indeed the first chair of the TRIPS Council in 1995 to 1996. And I'm also joined by Ambassador Mlumbi Peter from the Ambassador of South Africa, who is in fact the current chair of the Council for TRIPS for 2020 up until the end of the first meeting in 2021. Thank you both for having agreed to share your personal reflections on your times as chair, bearing in mind that these, of course, stem from very, very different periods, but I think they will be useful and enlightening for us to frame this day when we reflect on the last 25 years of the TRIPS agreement. So without any further ado, I would give the floor to Stuart Harbinson, who I hope will be able to activate his video and speak to us. Stuart? I hope you can hear me and you can take the floor now.
Thank you very much, Wolf. I hope you can hear me and see me. Good.
Yes, we can.
Well, of course, I'm very honored to be invited to take part in this event to mark 25 years of the TRIPS agreement. It's a subject of huge importance, as admirably outlined a moment ago by DDG Yi, and I'm very grateful to the WTO for inviting me. My reflections are, of course, largely from a historical perspective, which I hope may help to fill in some blanks. The extent to which they may have any relevance today is another matter, and indeed a matter for others to consider. I'd like to begin in 1994, because it would be wrong to think that nothing happened between the end of the Uruguay round and the birth of the WTO on the 1st of January 1995. There was, in fact, very intensive work in the preparatory committee for the WTO between April and December 1994. Peter Sutherland was chair of the PrepCom in his personal capacity, in other words, not as DG of the GATT. And the committee held 11 meetings in total within quite a short space of time. The PrepCom had 4 subcommittees, one of which had the catchy title of the Subcommittee on Institutional, Procedural and Legal Matters, which was known as the IPL Subcommittee. And this subcommittee in turn set up an informal contact group on TRIPS. The PrepCom held an implementation conference on the 19th of December 1994, confirming 1st of January 1995 as the date for entry into force of the WTO agreement. The IPL subcommittee considered issues like rules of procedure, relations with other international organizations, market access schedules in goods, accessions, and notification formats. This was, in fact, essential groundwork into which the contact group on TRIPS fed and which formed the basis for our operations in 1995. The contact group on TRIPS was chaired by Ambassador Kesavapani of Singapore, who was also the chair of the IPL subcommittee. He subsequently became the first chair of the WTO General Council. Pani, as he was known, was a universally respected figure. He constantly reminded us of the almost sacred mission we were embarking on, appealing, usually successfully, for a spirit of compromise, moderation, and self-restraint. The contact group on TRIPS, in which 64 delegations participated, focused on two main areas: cooperation with WIPO and notification procedures. In cooperation with WIPO, the contact group initiated a staged program of preparatory work, starting with establishing basic information about the relationship between the two organizations. The question of notification procedures was also closely related to cooperation with WIPO, since, of course, Article 63.2 of the TRIPS Agreement called for possible establishment of a common register. The general spirit was very good. In the light of everything that has happened since, it's quite hard to convey the positive mood. Members and Secretariat thought we were engaged on a really important mission, creating a new, unique instrument of global governance, which indeed we were. Of course, this did not mean that there were not heated arguments on some issues. At the PrepCom level, I recall that it was very difficult to agree on anything to do with textiles. The textilians, as Peter Sutherland used to call them rather disparagingly, were as ever recalcitrant. There was also the lively competition between Geneva and Bonn to be the seat of the WTO. It was all rather exciting, and even in some respects a bit of a cliffhanger. By September 1994, only 26 out of 125 participants had ratified the WTO agreement. Generally, we all felt that we were engaged on constructing something quite precious. The essential point I'm making here is that the TRIPS Council, and indeed the other organs of the WTO, did not miraculously appear out of nowhere in 1995. Much basic work had been done, and 1995 felt to a certain degree like part of a continuum. However, it was also very clear that we were no longer in the old GATT, but in a completely new context. The first meeting of the WTO General Council took place on the 31st of January 1995. It adopted the report of the Preparatory Committee and took a number of essential decisions, including approving a transfer agreement between the Interim Commission for the International Trade Organization, the GATT 1947, and the WTO. The Interim Commission for the International Trade Organization, in fact, had to meet for the first time in almost 50 years, which is an interesting story, but another story. General Council also approved a slate of chairs for the WTO's main bodies. Choice of a Hong Kong representative to be the first TRIPS Council chair was surprising in a way. Hong Kong had had an interesting journey in IP protection. In the 1980s, it was notorious as a regional center for counterfeit and piracy, especially in computer hardware and software, as well as luxury goods. The government eventually decided that this was not the right place to be. Despite domestic controversy, new laws were enacted, enforcement was radically stepped up, and a big effort in public education was made. By the early 1990s, the situation was transformed. The first year of the TRIPS Council itself could be characterized as installing the basic plumbing to implement the agreement. It was extremely busy as we had 6 meetings with extensive informal consultations intersessionally. In addition, there was the significant matter of drawing up a cooperation agreement between the WTO and WIPO. The general atmosphere was still highly cooperative, I would say, although, of course, we continued to have some disagreements. We all felt we had a collective duty to get everything up and running. Secretariat division responsible for TRIPS had just 2 professional officers on the subject, one of whom, Hanuwaga, is still in post. I see that he will in fact be speaking later this morning. Hanu certainly has the institutional memory. The division was led by Adrian Otten, who had other responsibilities in addition to TRIPS. Their guidance and advice to me was vital. Rules of procedure were drawn up and with some modifications following consultations agreed. One of the main areas of focus was notification procedures and the initial notifications themselves. These included Articles 1.3 and 3.1, Article 69 on contact points, and Article 4D on MFN. In most cases, we were able to reach agreement on how these should be handled. In particular, we agreed procedures for giving effect to the obligation to notify implementing legislation under the transparency provisions of Article 63.2. We also deliberated on how to implement Article 65.5 on transitional arrangements. I attempted to put forward a balanced approach under which there was no obligation to notify changes to legislation during the transitional period, but the Council should at least be informed. Reading some of the minutes from that time recently, actually for the first time, just to refresh my memory for this event, I was amused to be quoted as saying in September 1995 that I, quote, detected signs of incipient flexibility, unquote. I doubt that I actually said that, but it is nicely put, if over-optimistic as it turned out. Article 78 on patent protection for pharmaceutical and agricultural chemical products was fairly contentious in that notifications were slow in coming forward. Council discussed technical cooperation under Article 67 extensively. A useful Secretariat note described the main orientations, but there were disagreements as to scope. This was clearly going to be a long and ongoing conversation. Arrangements for cooperation with WIPO were, of course, a major area of effort. I recall initial conversations with Dr. Boksch, then the Director General of WIPO, over quite excellent lunches in his private dining room. Our main and very convivial interlocutor was, however, Ambassador Eladio Loizaga of Paraguay, who was then chair of the WIPO Coordination Committee. Conveniently, he was also ambassador to the WTO. Again, the WTO Secretariat, which enjoyed excellent relations with their counterparts in WIPO, was instrumental. After several meetings and informal consultations on both sides, we drew up a draft agreement between the World Intellectual Property Organization and the World Trade Organization. There was one hiccup over a provision which called for an amendment of the agreement in the event that there would be a new WTO member, which was neither a member state of the United Nations nor a member state of the WIPO. This provision was eventually dropped. The agreement was approved by the TRIPS Council and the General Council, and also, of course, by the WIPO governing bodies, and came into effect on the 1st of January 1996. So as DDG Yi said, is coming up for 25 years anniversary of that agreement. The agreement dealt mainly with accessibility of laws and regulations in the WIPO collection, transmission by the WTO Secretariat to WIPO of notified laws and regulations, implementation of Article 6(ter) of the Paris Convention for the purposes of the TRIPS agreement, and technical cooperation. All in all, I think we did manage to get the TRIPS Council up and running in a reasonably effective way. The credit must go primarily to the members, who usually adopted a constructive and cooperative approach. I think this shows how general atmospherics can affect outcomes. Personally, I very much enjoyed this experience and felt privileged to have been part of it. I have to say that although I was familiar with some of the basic principles of IP and TRIPS from my Hong Kong days, I was on a very steep learning curve when it came to the detail, and I had to rely a lot on the Secretariat. The experience confirmed my very high opinion of their professionalism, and the members generally shared my opinion. By the time I got up to anything like the minimum speed, however, it was time to move on. I suspect that I would not be alone among at least some of the TRIPS chairs in feeling like that. It is a specialized area which requires significant time and application. Would it be useful for chairs of some WTO bodies, say like the TRIPS Council, to be appointed for 2 years rather than 1, to provide some continuity in the so-called political leadership? If not, should there at least be some more flexibility as to terms of office? I'll leave that thought with you. As a footnote, let me add that my foray into TRIPS in 1995-96 proved very useful to me 4 years later, when, as chair of the General Council, I had to consult on the draft declaration on the TRIPS agreement and public health, which was mentioned by DDG Yi in the run-up to the Doha Ministerial Conference in the year 2000. I am certainly not claiming credit for that. This very sensitive issue was skillfully handled by the delegations primarily involved, by Director General Mike Moore, who very sadly passed away in February of this year, and by the Secretariat. I would actually like to say a word about Mike Moore in closing, because he did not always get the credit that was due to him. He felt deeply that the WTO had to deliver on this issue of TRIPS and public health. We worked together on many subjects as DG and General Council Chair. I know from my close personal contact with him at the time that he was constantly on the phone to ministers and to CEOs of major pharmaceutical companies. And typically, because Mike wouldn't take no for an answer when he believed in a cause, he succeeded in the end. Finally, these are, as we all know, very challenging times for the WTO. Let me wish everyone currently involved in TRIPS well, most especially, of course, Ambassador Mulumbi Peter. I would encourage all of you in a positive spirit to leave no stone unturned in your efforts to find consensus on the issues you are dealing with. In doing so, perhaps like me, you might even be able to detect signs of incipient flexibility. Thank you very much.
Thank you very much, Stuart, for this rich array of memories that takes us back to the early days and highlights how the TRIPS Council functioned and what atmosphere was salient when it was set up. Thank you also for highlighting the work on the WIPO-WTO agreement, which indeed will be celebrated, we hope, together with WIPO early next year, and also on your personal views on Mike Moore, which I'm sure will not go unheard. Let me now turn to Ambassador Mlumbi Peter. Thank you for being with us this morning and making the time to share your personal views on your current chairmanship of the TRIPS Council with us. Ambassador, you have the floor.
Thank you very much, Wolf, for the invite. Let me start by thanking DDGE for the opening remarks and Stuart for the reflections and also for outlining the work that continues to provide a good foundation for the work of the Council and your contribution. We are marking the 25 years of the TRIPS agreement when the world is facing an exceptional crisis of our time that is testing the health systems across the world. The pandemic is affecting both developed and developing countries alike, so this is a shared challenge. Without a doubt, developing countries will be disproportionately impacted, not only from a health perspective, but more from an economic and socio-economic point of view. The challenge is to ensure an efficient and global solution to this pandemic. As DDGE stated, the WTO during the Doha Ministerial Conference took an unprecedented step of adopting the Declaration on the TRIPS Agreement and Public Health. The declaration provided the much needed clarity that the TRIPS Agreement should not prevent members from adopting measures necessary to ensure access to medicines, that the agreement can and should be interpreted and implemented in a manner that is supportive to WTO members' right to protect public health and in particular to promote access to medicines for all. In this connection, members reaffirmed the right of WTO members to use to the full the provisions in the TRIPS agreement, which provide the flexibility for this purpose. Further, while recognizing that IP protection is important for the development of new medicines, members also acknowledge the concerns about its effects on prices. Progress has therefore been made in relation to the interface between the TRIPS agreement and public health. The question is whether the provisions of the TRIPS agreement and the flexibilities entailed therein are sufficient to respond to an unprecedented crisis as we see today. In the discussions that are currently ensuing in the TRIPS Council, members agree on the role of IP to innovation and research and development. Members also recognize the effects of COVID-19 on the global community and the need for multilateral cooperation. They also agree that the common objective is to ensure swift delivery of COVID-19 vaccines and therapeutics. There is also recognition that no one is safe until all are. With the evidence of the second wave in some regions of the world, it is clear that the calamity of the pandemic is far from over. There is a discussion taking place in the Council on a proposal made by a number of developing countries on a TRIPS waiver that suspends specific provisions of the TRIPS agreement for the prevention, containment, and treatment of COVID-19. What is clear from this discussion is that the TRIPS agreement needs to be part of the wider national and international action to address the pandemic. Members will need to carefully listen to each other's concerns and engage in a solution-oriented discussion, as already stated by Stuart. As stated by the IMF Managing Director before the G20 summit, global cooperation is required to increase multilateral efforts on the manufacturing, purchase, and distribution of vaccines, treatments, and tests, especially for low-income nations, in the interest of humanity. I remain optimistic that members will work together, understanding the gravity of the challenge and the need to work together to find a balanced solution that achieves the commonly shared objective of ensuring equitable, timely, and affordable access to the vaccines, medical products, and therapeutics. Such a solution must result in a resilient system that not only responds to the current crisis, but also prepares the WTO for future crises. This is especially relevant given the warning by scientists that we are likely to see an increase in zoonotic diseases in future. When I took over the chair of the TRIPS Council, I did not anticipate the magnitude of the crisis that is currently bedeviling the world and how important the work of the Council will be in discussions towards a multilateral solution to the pandemic. I also recognize that the solution will come from constructive engagement from the members. And we are doing what we can to facilitate discussions among members in this regard. The TRIPS agreement also provides and covers a number of developmental issues. It is a minimum standards agreement. As stated in Article 1 of the TRIPS agreement, members are free to determine the appropriate method of implementing the provisions of the agreement within their own legal system. However, the TRIPS agreement contains complex and sometimes not well understood provisions, especially among developing countries. The proper understanding is important in designing national IP systems that strike the delicate balance between protecting the rights of producers of knowledge, innovation, and research and development, as well as social welfare, including when privately owned knowledge enters the public domain to enable industrial as well as socio-economic development. The TRIPS agreement also provides a set of flexibilities that the WTO members can utilize to protect or achieve public interests, such as public health. These include compulsory licensing, government use licenses, as well as parallel imports, to name but a few. These are legal instruments that are widely recognized in the laws of both developed and developing countries that can be used to address a variety of situations, such as insufficient supply or excess prices of products, and as well as national emergencies. They can be in particular necessary to implement public policies aiming at ensuring the production or procurement of medicines and other health technologies in situations of global health crisis such as COVID-19. In addition, the Doha Declaration on the TRIPS Agreement and Public Health, in terms of subparagraph 5b, recognizes that each member has the right to grant compulsory licenses and the freedom to determine the grounds upon which licenses are granted. It is important to note that concrete application and grant of a compulsory license or government use will necessarily be subject to the provisions of the applicable national law. Some members, while recognizing the value of these flexibilities, are raising legislative as well as institutional capacity constraints, as well as difficulties in invoking the flexibilities on product-specific basis across a wide range of health products, which may be cumbersome in a time of a global pandemic. Other members are of the view that these are sufficient to respond to the pandemic. And as I said, the discussion is taking place in the context of this pandemic to find a middle ground and a landing zone that is in the interest of all members. The TRIPS agreement also contains Ldc specific provisions, such as Article 66.1 on general transition period for all IP areas that has been extended twice and is ending on the 1st of July 2021. And in this regard, the LDCs have submitted a duly motivated request in the October TRIPS Council for a further extension for consideration by members. And the Doha Declaration on TRIPS and Public Health also extended the transition period for pharmaceuticals until the 1st of January 2033. We also have Article 66.2 that obliges developed country members to provide incentives to enterprises and institutions in their territories to promote technology transfer to LDCs in order to enable them to create a sound and viable technological base. LDCs have made a submission on the types of programs to achieve this objective and have also proposed a template to facilitate targeted reporting under Article 66.2 in an attempt to provide the requisite clarity on the support that they need in this regard. Article 67 also makes provision for technical cooperation to developing countries as well as LDCs. Of course, the work of the Council is focusing on the issues of public health, but this is not the only issue that occupies the work of the Council. There is regular work that includes, as also referred to by Stuart, the importance of transparency and notification obligations. And this has also been very important in the context of COVID-19, where members are notifying legislative changes, including those that relate to addressing COVID-19. And this continues to be an issue of interest to members. There's also a discussion on non-violation complaints because there's a ministerial conference that has directed the Council to continue examining the scope and modalities for non-violation and situation complaints and to make this recommendation to MC12. In the meantime, members have agreed not to initiate such complaints under the TRIPS agreement, and these discussions are continuing. Members are also putting forward in the agenda ad hoc items on critical as well as topical issues that have implications on IP. And this is an important contribution by members to facilitate sharing of information as well as exchange of views on these critical issues among members. Now, coming to, given the fact that we now are marking 25 years, what could be the issues of reflection for the next 25 years? I think if we look at the objectives as well as the principles as outlined in Article 7 and 8 of the TRIPS agreement, in my view, they remain relevant as a guide on what the objectives of the TRIPS Council should be and the TRIPS agreement going forward. If you look at Article 7, it states that the protection and enforcement of IP rights should contribute to the promotion of technological innovation, contribute to the transfer and dissemination of technology, must be to the mutual advantage of producers and users of technological knowledge, be done in a manner conducive to social and economic welfare, and to a balance of rights and obligations. Article 8 emphasizes the protection of public health and nutrition, the importance of public interest, and international technology transfer. We also need to work to continue the outstanding work on issues that are outstanding within the TRIPS Council, but also with ministerial mandates. We need to note that the TRIPS agreement requires a review of Article 27.3b, which deals with the patentability or non-patentability of plant and animal inventions and the protection of plant varieties. And paragraph 19 of the Doha Declaration broadened the discussion and called on the Council to look at the relationship between the TRIPS agreement and the UN Convention on Biological Diversity, the protection of traditional knowledge and folklore. And these issues remain outstanding, and members continue to discuss on how to advance such discussions. Furthermore, members will need to reflect on the best approach to the transition under Article 66.1, whether it should be a temporary waiver or, as proposed by the LDCs, the provisions be waived as long as a member is an LDC to avoid having to submit a duly motivated request every time the waiver expires. In addition, a reflection is required on the challenges that are faced by graduating LDCs to address their vulnerabilities and to enable a more seamless transition, which is entailed in the proposal that has been submitted by the LDCs to the Council. Chair, COVID-19 has also demonstrated the importance of the TRIPS flexibilities. It is important for members that are yet to accept the paragraph 6 amendment to do so. In this regard, there are 33 members and the 2021 deadline is approaching. In addition, some members have not domesticated the TRIPS flexibilities into national law, making it difficult to invoke these flexibilities. Members will need to consider as appropriate the review of national legislation to enable the full use of the flexibilities as provided for under the TRIPS agreement and the Doha Declaration on Public Health. In addition, COVID-19 has highlighted the importance of e-commerce, but also digital divide. In this regard, the 1998 Work Programme mandates the Council for TRIPS to examine the intellectual property issues arising in connection with electronic commerce. Members must also revitalize the mandated reviews of the TRIPS Council under Article 71.1, which could be very useful for members to share information as well as experiences in implementing the TRIPS agreement. In conclusion, Chair, we must ensure that the discussions on WTO reform, which is a topical issue within the WTO, preserves the objectives that have been set out in the TRIPS agreement and also explore how IP can facilitate inclusive growth and development, including how IP can contribute to sustainable development goals, and in recognition that the IP system must protect IP for the benefit of producers of IPR and also promote social welfare. IP is critical to the knowledge economy. So as we consider how to build better, we need to reflect on its contribution in a manner that benefits all. Thanks, Chair.
Thank you very much, Ambassador Mlumbi-Peter, for this extensive overview of the Council's work and your personal reflections in this regard. I think this has set the scene very well for the rest of today's presentations that will try and track the activity of the TRIPS Council over the last 25 years. I think if the two speakers will indulge me, I think there's been one question that we've received, and if they have a moment to maybe still switch on their videos to see whether they might be willing to respond to this. I don't know whether Stuart is still here. Thank you, yes. So the question we've received is what kind of advice the first chair of the TRIPS Council would have for the current chair, and what the current chair would like to ask the first chair in terms of advice. So this is a very broad question, but I think it might be a nice way to close out this meeting. So I leave it to you. Who wants to go first?
Maybe I should start. Maybe the question that I would like to ask Stuart is, given the sensitivity of the issues, especially in relation to public health, the importance of the issues, what would be your advice to the chair in terms of how to facilitate a constructive discussion among members? Thanks, Wolf.
Well, there's an easy question for you, Stuart.
Well, thanks for the question. It's a very interesting one. I mean, I feel rather diffident about offering advice, given the 25-year gap between my my chairmanship and the current chairmanship, because it's a completely different context. I guess what I was trying to convey in my remarks is that there was a certain spirit in those days, that we really did think we were in the process of creating something quite precious in the world. And as I said, of course, that didn't mean that we didn't have disagreements, but there was a lot more self-restraint, I feel. I have that impression, just as an observer of the WTO from the outside now. In those days, people were more moderate. They held back more. There was an attempt to try to see the other side's point of view, and there was less digging of trenches. And I don't think this is something necessarily that a chair can accomplish, but I think it's a message for the members, really, primarily, that they need, if they really value the system, and of course they all say they value the system, but if they actually do value the system, they need to match their words with a bit of action and try to find ways of detecting incipient flexibility, as I put it. So that would be my messages to the members, really, I think, rather than to the chair. Of course, leadership is important to a certain extent, and I'm sure Ambassador Mlumbi Peter will be providing that leadership. I think it's a bit unfortunate that we don't have a Director General in the WTO now, because as I said, when I was consulting on TRIPS and public health in 2000, the DG's role was very, very important behind the scenes. So that would be something that it would be nice to have a Director General, I would say, would be my other remark. But I think I'll stop there. Thank you.
Thank you very much for this exchange. I think this is pretty much all we have time for. Thank you both again for taking the time to share with us and to frame the discussion with this, of course, very topical current theme. Even though most of this morning's session will be taking a broader view and not focusing necessarily on the public health question. So thank you again for your interventions and for being with us this morning. So I will now move to the first theme of today, which is the impact of TRIPS on the global IP system. And I would like to maybe first remind participants that the program for this event can be found on the dedicated TRIPS webpage of the Secretariat. I've put the link to there in the chat just now. It is www.wto.org/TRIPS@25. This is a webpage where you will also find material that is produced by the Secretariat and forward-looking events that will continue to commemorate the 25 years of the TRIPS agreement. So that's a good place to always check back for more information. So according to that program, we are now, as I said, moving to theme 1, the impact of the TRIPS on the global system. Maybe just to remind you again that interpretation is, of course, available through the interpretation symbol at the bottom of your Zoom screen. I would also like to highlight that this event is, of course, conceived as an informal, set of informal and open-ended conversations. Our TRIPS colleagues will be speaking, are drawing on their practical experience that they've built over many years, and they offer insights drawn from their professional perspectives in order to be interesting for you But that also means, of course, and we would like to emphasize this, that these are not official views and they should not be attributed to the WTO, its Secretariat, or its members in this regard. I think the second thing to say is, as I've already mentioned, we're very conscious that there is an urgent discussion of matters of public health that is of immediate concern to members and which members are rightly discussing with a high degree of priority. So the fact that today's event commemorating 25 years of TRIPS takes a broader view and does not necessarily focus on this question does not mean that we want to diminish or detract attention from these issues discussed among members. So with this remarks, let me remind you again that questions could always be posed in the chat or in the question and answer function of Zoom, or you can send these to ipd@wto.org. With that, I would like to give the floor to the intervention on TRIPS and the global IP system by Anthony Taubman. Anthony Taubman is the director of the Intellectual Property, Government, Procurement and Competition Division in the WTO Secretariat. He's well known to most of you, and I'm glad to hand over the floor now to you, Tony.
Thank you very much. Thank you very much, Wolf, and good morning, good afternoon, good evening to all of you who have joined us from across the globe. I join my colleagues in thanking you most warmly for joining us for today's symposium. And I'd like especially to acknowledge the former chair of the TRIPS Council in its incipient years, Mr. Stuart Harbinson, and our current TRIPS Council chair, Ambassador Mlumbi Peter, for so magisterially setting the scene for us today, which I think has impressed on us both the depth of experience that we've undertaken in implementing the TRIPS agreement, but also the very current topical issues that are before the TRIPS Council now. I'm fortunate to work with some remarkable colleagues in the TRIPS group within the WTO Secretariat. In the following session, they're going to put before you some of the practical insights that we have gleaned from the rich and diverse vein of information that has built up over the past quarter century as the TRIPS agreement has been implemented in diverse ways. My simpler task this morning is to set these understandings within their broader historic context. As Wolf has mentioned, we're sharing these views as personal perspectives rather than as any kind of official account, and certainly not to advocate or push for any policy or legal position. Our more modest goal this morning is to contribute to a richer, contemporary, forward-looking conversation, a much needed conversation, I'd say, about the insights that can be learnt from this practical experience. But we are all conscious, and previous speakers have stressed this, that 2020 will be above all remembered for the devastating pandemic that has touched communities across the globe. Indeed, our earlier plans to mark the 25th anniversary of TRIPS, like so many plans in this calamitous year, were entirely upended by the pandemic. And the urgent, pressing concerns of our member governments as they seek to tackle this global health crisis, of course, overshadow our reflections today. And Ambassador Mlumbi Peter, the TRIPS Council Chair, has outlined these again in a magisterial manner. Therefore, our immediate responsibilities as the Secretariat of an intergovernmental organisation, as always, but especially now in a time of crisis, are naturally to serve our member governments by providing the technical assistance and the support they call for, alongside our valued international partners, such as the World Health Organization, World Intellectual Property Organization, who I'm glad to acknowledge today. So even while we take the time briefly today to take that broader view, we do stress our immediate duty as to serve our member governments and to acknowledge the intensive dialogue between our members concerning the pandemic response within and beyond the framework of TRIPS. Again, very helpfully outlined by our TRIPS Council Chair. Our role in the Secretariat is therefore to concentrate on the established framework that these governments have assigned to us and to follow the choices that they take. Now, in opening up what I hope is a broader, more diverse view of the significance of TRIPS, my theme today is simply that we need to understand and respond to the experience of the last quarter century in a holistic and inclusive manner, with a view to distilling and learning from the extraordinary breadth of practical experience gained. Countless officials, negotiators, lawyers, civil society advocates, business representatives, analysts and scholars have all encountered the TRIPS agreement, but in diverse contexts, and they bring forward sometimes startling divergent understandings of its very character, significance, its impact. Even though its text as an international treaty has essentially been settled since 1990, with the vitally important exception, of course, as has been mentioned, of the one amendment made to create a fresh legal pathway for affordable medicines for the most vulnerable countries, and indeed the important clarification, as Ambassador Mulmi-Peters mentioned, of the Doha Declaration on the TRIPS Agreement and Public Health, extremely salient for us today. But in taking this broader view, I would argue that it's vital to develop a holistic, inclusive perspective of this diverse experience, even in a time of immediate crisis, as there are fundamental issues of international relations and economic and social development at stake, and we simply cannot afford to overlook the invaluable practical lessons to be learnt. Over 30 years ago, the TRIPS negotiators were debating the very character of their negotiating mandate. What are the purported trade-related aspects of intellectual property? And then, more profoundly, they touched on the question, well, why do we have an intellectual property system anyway? Quite literally, what is it there for? These questions remain very current for us today. Looking outward, how does the sometimes dauntingly technical field of intellectual property fit into a broader, ever diversifying policy landscape, embracing the complex, sometimes contested field of trade policy, certainly, but also bearing on the full context of sustainable development? For example, the challenges for medical innovation and ensuring access to the fruits of that innovation, as we are considering acutely today, but also the wider challenges for humanity at a time when we look to the creation and sharing of knowledge as a critical ingredient for sustainable development. Then, looking inward, if the intellectual property system is indeed to serve its proper functions as a practical tool of public policy, how can it best be harnessed, adapted, and fine-tuned so as to optimally deliver on its purported objectives in ways that correspond to the diverse and the fast evolving needs and circumstances of the WTO's 164 members? What we can conclude from all of the experience garnered over the years that we'll be sharing with you this morning within the broad framework of TRIPS is that these are dynamic, supple, nuanced questions which have been addressed in ever more diverse ways across the globe. And they are questions in continuous need of interrogation and reconsideration in the light of changing developments. After all, the technological, economic, trade, cultural, and social contexts for the intellectual property system have been utterly transformed since the ink dried on that concluded agreement a full generation ago. Consider the very nature of trade itself. The TRIPS negotiations were convened under the heading of trade in goods. They stemmed indeed from earlier attempts to stem the flow of trade in counterfeit goods. Intellectual property by trade negotiators was conceived essentially as part of the value added embedded in physical goods. So if you imported music, you imported a thing, a disc, and those could be counted as trade in goods. Today, it's remarkably different. Intellectual property rights are traded internationally in their own right, if you like, as tradable goods in themselves. For instance, in the billions of transactions on platforms for software apps and for creative content, digital music, books, video works, and so on. And today's dispersed global production chains are tied together in part by the myriad licenses for the intellectual property ingredients, those streams of knowledge, those streams of know-how that help transform raw materials into sophisticated products, such as the very device on which you're viewing today's event. These knowledge transfers, in turn, offer a valuable source of technological development for emerging economies. The origins of this dramatically transformed landscape today, I think, are exemplified in the surprising convergence of three separate developments that we can date squarely to the year 1990. First, 1990 saw the publication of Professor Paul Romer's landmark paper, Endogenous Technical Change. Excuse the technicalities, but Professor Romer discussed how technological change, and what he termed more concretely, improvement in the instructions for mixing together raw materials, was a central factor in enabling economic growth. Knowledge was no longer set aside in a so-called exogenous black box. It was endogenous, it was integral to the model for economic growth and development. He considered the role of incentives in the process whereby new knowledge is translated into goods with practical value. And he explained that compared to the economics of managing zero-sum choices over scarce physical goods, ideas are distinctive in that they are inherently non-rivalrous. You can use my ideas without diminishing my access to my ideas. As he put it, instructions for working with raw materials are inherently different from other economic goods. Discoveries differ from other inputs in the sense that many people can use them at the same time. Second, it was also in 1990 that the substance of what emerged as the TRIPS agreement largely took shape. In the draft text known as the Brussels text, while still very much contested between negotiators, the proposed provisions for TRIPS already showed the fruits of substantive engagement by negotiators, blending proposals for standards for intellectual property protection, positive standards, with measures to balance rights and obligations, and articulating the positive sum policy role of the intellectual property system, the kind of provisions, again, that Ambassador Mulumbi-Peter has referred to. Third, also in 1990, at the research institution CERN, the nuclear research institution CERN, which coincidentally is just a few kilometers from the parallel TRIPS negotiations in Geneva, Tim Berners-Lee was conceiving the World Wide Web, based in part on his observations of the actual patterns of collaborative knowledge sharing by the researchers at CERN. The web has, of course, since exemplified in practice the non-rivalrous characteristic of knowledge by enabling its seemingly limitless sharing across the globe. It has, of course, transformed the ways in which intellectual property is defined, administered, managed, shared, and enforced, and it has created remarkable opportunities for transparency in governance and for the dissemination of the technological knowledge contained in patent documents. These three developments, taken together, have contributed to the transformation over the decades since then in a way that's immediately relevant to our discussions today. First, an understanding of the distinctive characteristic of knowledge goods as a foundation for development. Second, a clear articulation of the very policy purpose of a balanced, positive sum intellectual property system. And third, the technological possibilities for the seamless sharing of knowledge globally. We have learnt from the original TRIPS negotiators. We invited them back 5 years ago as a kind of class reunion to discuss their experiences. And for those with an interest, I refer to the edited book, The Making of TRIPS, which captures this experience. Those representing the leading developing countries in the negotiations recalled that their insistence on articulating the very policy role of the intellectual property system, especially what emerged as Article 7 of the TRIPS agreement today, and the principles in Article 8 that again our chair, Ambassador Mulumbi-Peter, has referred to, This was not an abstract or aspirational ideal, but rather part of a set of deliberate pragmatic safeguards for maintaining continuing capacity to pursue policy options and flexibilities, which would be essential back home for their implementation of TRIPS standards in a manner better adapted to their evolving domestic needs and circumstances. Since then, formulation for the intellectual property system expressed in Article 7 of TRIPS has served as a foundation for a continuing, vigorous and diverse international conversation about what forms of international IP law and policy both promote innovation and technological diffusion for social and economic welfare, and what it means in practice to strike a balance of rights and obligations. Without venturing into the realm of treaty interpretation, the should of Article 7, the injunction of Article 7 that intellectual property should contribute to these goals, it's clearly a compelling benchmark for IP policymakers still today. I therefore conclude by reflecting on our practical experience with the actual implementation of the TRIPS agreement in its several dimensions over a quarter century, valuably sheds light on critical policy issues and the diverse choices governments have taken across the globe to give effect to that should of Article 7, the expectations of a balance of rights and obligations, a positive sum contribution to knowledge generation and diffusion, and the promotion of social and economic welfare. An extraordinarily challenging task and one that governments across the globe have taken up with great energy and application. Of course, it would be naive to overlook the sometimes contentious character of intellectual property in international relations. Indeed, the very preamble of TRIPS recalls the disputes in the 1980s over trade and intellectual property that in part drove forward those negotiations. The TRIPS agreement is the only WTO agreement to refer expressly to the importance of reducing international tensions by reaching strengthened commitments to resolve disputes through multilateral procedures. And we know that today, virtually 3 decades later, intellectual property remains potentially a point of contention to some extent in international relations. Yet, while recognizing that aspect of intellectual property in international relations, I would like very tentatively to offer for your consideration what is perhaps an heretical suggestion that the TRIPS agreement can also operate as a framework for multilateral collaboration or cooperation, for the pooling of resources, as a platform for policy debate and analysis, for transparency and governance, and as a pathway for coherence with public international law and policy, and for mutual learning on the basis of this practical experience. Understanding the full spectrum of TRIPS implementation is to understand the countless, ever-diversifying and transformative ways that national systems have employed to respond to that challenge of the should of Article 7, the public benefits the intellectual property system is meant to deliver. My colleagues will be exploring these now. For instance, we have the policy insights from thousands of pieces of legislation from some 150 jurisdictions, giving effect in diverse ways to the balanced principles and standards of TRIPS, while continuing to adapt them to evolving domestic needs and circumstances. We know of thousands of judicial decisions that also consider the provisions of TRIPS and seek to apply them in balancing interests in the real world of litigation. And in some cases, courts have applied TRIPS provisions directly as domestic law. Of course, there are countless decisions by intellectual property officers to grant or refuse intellectual property rights. In so doing, giving the most direct practical effects to the general principles of TRIPS, which seek to define those aspects, those contributions to knowledge that are most beneficial as innovations, as creations. We've also tracked many programs of technical cooperation that have included institution building and have contributed to the extraordinary growth of expertise and independent policymaking capacity across the developing world. over the past 2 decades. And we have also recorded and discussed programs for technology transfer and for building technological capacity that least developed countries are entitled to under the agreement, again, as Ambassador Mulmi-Peter has recalled. We have also the findings of dispute settlement cases convened at the WTO that have illuminated with greater precision how the interests of IP right holders can be balanced against public policy issues and the legitimate interests of others. Hundreds of trade policy reviews have shown how WTO members across the spectrum of development have sought to advance the policy objectives of their IP systems on remarkably diverse yet topical issues of great policy interest and practical interest. Examples include ensuring patent quality, ensuring balanced IP protection in the digital environment, and addressing the interface between intellectual property and competition policy. The work of the TRIPS Council itself, the key IP body in the WTO, has served as a unique policy forum, most recently exploring our members' many practical approaches to promoting innovation policy and addressing the public interest dimension of intellectual property. The TRIPS agreement even finds an imprint in the diverse bilateral and regional agreements that acknowledge the balance of rights and obligations established under the TRIPS agreement and that are clarified in the Doha Declaration on TRIPS and Public Health. In short, over these 25 years, we have witnessed an extraordinary and unprecedented process of revising and updating intellectual property law and the development and even creation of intellectual property offices across the globe, with many developing countries undertaking fundamental programs of legislative and institutional development. We've also seen a growth of policy debate and analysis, and an extraordinary program of building and sharing expertise and policy capacity, with developing countries again taking major steps to build their expertise, their independent capacity to analyze and develop intellectual property policies, and to manage their IP systems as tools for public policy in line with the domestic needs and priorities. But I will be leaving you in the hands of my colleagues now, who will elaborate on these various dimensions more ably than I can. I'd like to conclude with a quote returning to Professor Romer, who I cited earlier. He received the 28th Nobel Prize for Economics for his work, and I quote from his Nobel Prize lecture: "The unique characteristics of ideas make material progress possible, but that's not all. Ideas matter not just for what humans have, but also for how they are. During the Pleistocene, human nature evolved in a Malthusian world of objects. We developed an ugly tendency to split humanity into us and them. A world that also includes ideas justifies a new mindset that treats all humans with the dignity and respect that we offer to us. It is a world in which we may derive net material benefits from the presence of others." So, in concluding, I stress I do reflect on this perspective frequently, even in our day-to-day work in the building behind me, and I invite you to reflect also on those possibilities. We hope that today's symposium will open up that kind of conversation to lead us forward into the future. I thank you very much for your patience and your attention, and I look forward to the interaction through the course of today. Thank you so much.
Thank you very much, Tony. I think this has very ably set the scene with the observations across the 25 years of the TRIPS Council and the underpinnings and the thought construct behind the TRIPS agreement in particular. The objectives of the TRIPS agreement that have been cited also by the current chair. The TRIPS agreement. Just to remind you that the program can be found on the WTO webpage dedicated to TRIPS 25. And on that page, there's also a link to the book that Tony mentioned, The Making of the TRIPS Agreement, which Tony, together with colleagues, edited for the 20th anniversary of the TRIPS Agreement. I now have the honor to moderate this morning's remaining session, which is entitled The TRIPS Council, Tracking the Legal and Institutional Development of IP Systems Over 25 Years. And this session will give us the opportunity not only to activate each of our colleagues from the TRIPS division. I'm glad to report that we are no longer only 2 professionals, as at the time of Stuart Harbinson. We've slightly improved, but we're still small and have multiple tasks to fulfill. But all of us will be taking the floor to highlight a number of aspects of the TRIPS Council's work and of the TRIPS Agreement's operation over the last 25 years. So I'll be providing a little bit of context for each of these interventions, given that we are all dispersed due to the pandemic. Some of our colleagues have chosen to record their interventions, which makes them less prone to technical problems. We will start with a theme that has been mentioned a number of times already this morning by DDG Yi, but also by Stuart Harbinson, which is in fact the extraordinary efforts that countries went through at the time of the coming into force of the TRIPS Agreement. Again, when TRIPS became applicable to developing countries, and on an individual basis for countries acceding to the WTO and the TRIPS Agreement, the extraordinary efforts these countries make in modernizing, overhauling, and in some cases constructing their IP systems. It is something that, as Tony mentioned, may be very much taken for granted today, but it is quite a tremendous investment that these countries make in their infrastructure in this regard. And evidence of this, in part, comes to the TRIPS Council and thus onto the international scene through notifications to the TRIPS Council. You have heard from Stuart Harbinson that setting out the rules on how these notifications should be effected was a significant part of the work of the TRIPS Council in the first year. And it's true that the guidelines and the requirements for such notifications that have since reached the TRIPS Council, and they number in the thousands, as Tony said by now, were set in those early years, and they still provide the basis for this important transparency mechanism. This gives us a chance also to showcase a recent innovation in the operation of these notifications. The eTRIPS system, of which many of you will have heard, was conceived to not only facilitate submission of such notifications, but also make it easier to access, view, and interrogate these past submissions so that it is easier to actually learn about the legal systems that members have put in place individually to implement TRIPS at their national level. So for an overview of what we've learned of these efforts of acceding countries or countries that implement and continue to notify the TRIPS Council of amendments of their IP systems, I hand over now to Natalie Carlson, who's the legal analyst in the IP division, and who is partly also responsible for large parts of operating the eTRIPS system, and therefore best placed to give us lessons from eTRIPS on members' notification on their national legislation. So over to you, Natalie.
It's an honor to be able to share with you today a few lessons that we can take away from the past 25 years of the TRIPS Agreement. thanks to the information that members have labored to provide pursuant to the transparency provisions in the agreement and the new eTrips online platform that was launched this past year, which makes these materials much more accessible and digestible than ever before. Now, as you know, transparency is among the founding principles of the WTO. This principle is also embedded in the TRIPS agreement. Article 68 obliges the TRIPS Council to monitor the operation of the agreement, and a number of transparency tools were into the agreement to support this monitoring function. And some of them have been complemented and supplemented by the Council. Now, they fall generally into three broad categories: notifications, reviews, and reports. Reports will be discussed in separate sessions, so we're going to focus on the lessons that we can learn from the materials that members have submitted to satisfy their notification obligations and to further mandated reviews. Now, more specifically, we're going to consider the results of 25 years of IP law notifications and responses to checklists, the checklist on enforcement measures, and the checklist that members were invited to respond to pursuant to the reviews of members implementing provisions concerning geographical indications and the review of members' approaches to biotechnology patenting. Now, together, these materials provide a particularly rich source of information on members' efforts to implement the agreement, as well as the evolution of their IP systems. So turning first to IP laws, members have submitted a really extraordinary amount of documentation relating to their IP laws and regulations. The bars on this graph show the number of notifications of IP laws and regulations made each year over the past 25 years, while the line accumulates the notifications and represents a running total. Now, as of last week, nearly 5,400 notifications have been made pertaining to over 4,000 distinct laws and regulations. Now, although the coverage of these materials is uneven, some members have been better than others at keeping up with the notification obligations and at keeping the Council apprised of changes to their IP laws. This still forms a truly unique and impressive collection of materials that spans 138 members and the entire scope of the agreement, as depicted in this figure. So the size of each square in this figure is directly proportional to the number of notified laws and regulations relating to that subject area. It's interesting to observe that members have notified the most laws relating to patents, including patent variety, plant variety protection, copyright and related rights, enforcement, and trademarks. Now, when we break these notifications down by date and by level of development, a very interesting thing happens. We essentially create a map of members' efforts to initially implement the agreement and then over time support the Council's monitoring function by submitting updates to their initial notifications. Now, looking at the graph, you can see that LDC members, represented by the pink line along the bottom, are mostly availing themselves of a transition period that entitles them to defer implementing the substantive obligations of the agreement. Now, turning to the blue line associated with developed country members, the spike of notifications in 1996 correlates with the year that the substantive provisions of the agreement took effect for them. And a similar pattern can be seen for developing and emerging economies. The peak in 2000 correlates with the date that the agreement took effect for those economies. Now, after 2000, you see occasional smaller spikes in notifications, which are often associated with the agreement coming into force for a new acceding member of the WTO. But since about 2003, the overall trend has stabilized a bit, as most members have transitioned from notifying implementing laws to supporting the Council's continuous monitoring function by notifying amendments to previously notified laws. Now, we can take the notifications of Hong Kong, China as an example of this. Notifications to the Council are classified as first notifications, amendments or revisions to a first notification, or replacements or consolidations of first notification. In 1997, Hong Kong, China submitted a notification informing the Council of its compliance with the non-discrimination principles of national treatment and most favored nation treatment. when the main provisions of the agreement came into effect for it in 2000, it then notified its implementing legislation, represented by the 61 first notifications that you see in the purple bar. Now, in the years that followed, it continued to regularly update the Council on the evolution of its IP regime, because as with many members, their IP regime didn't stand still after 2000. Existing laws were amended and new laws were passed to keep up with new developments in technology and shifting priorities. Now, we can also review the scope of Hong Kong, China's notified laws and get a snapshot of the subject areas that have been notified most frequently and those that have been the subject of the most legislative activity. We can see that the subject areas that have been the subject of the most legislative activity overall are those that are highlighted now in the blue square. But we can also quickly identify those subject areas that have been the subject of the most legislative activity since Hong Kong first implemented the agreement, as indicated by the pink and gray portions of the bars. Now, thanks to the efforts of members like Hong Kong, China, and many others, members and now the public can access a tremendous amount of information about the implementation of the agreement, as well as the subsequent evolution of IP systems. So all of the data we've considered thus far has been generated from members' notifications of their IP laws and is readily available to the public via the eTrips gateway. But we can also learn quite a bit of information about members' responses to checklists of questions in the areas of enforcement, geographical indications, and biotech patenting. So 112 members have responded to questions concerning their enforcement regimes, while 37 have provided responses to questions regarding geographical indications, and 27 on biotech patenting and related questions. Now, these checklist responses are a particularly powerful source of information because they provide plain English descriptions of members' laws and practices in these areas and can be easily compared across jurisdictions, offering insight into policy choices. So here's a simple example. This is a snapshot of a recent report generated from eTrips that retrieved all of the responses to a question that I chose from the enforcement checklist. Specifically, I wanted to know how members responded to checklist question 41, which asks, in respect of which infringements of which intellectual property rights are criminal procedures and penalties available? Now, on the left-hand side is a list of the members who provided responses to this question and the document symbol in which their response was circulated. On the right is the response. Now, this is a really powerful tool because it allows policymakers to very quickly determine both consistencies and variations among approaches between members. So it can serve as a very valuable point of reference if and when a member reconsiders certain policies. So this type of report can be generated from any question on any of the three checklists on enforcement, geographical indications, and biotech patenting. Now, I'd like to conclude with a note of thanks. Thanks to you for your time and attention, but also thank you to WTO members, many of whom have gone to great lengths to provide detailed and up-to-date information on their IP systems. Now, as a result of those efforts, members, academics, and civil society now have really a wealth of information from around the world at their fingertips, which demonstrates the scale of the legislative overhaul that was triggered by the TRIPS agreement and provides insight into the policy choices that have been made and indeed continue to be made by members as they adapt their IP regimes to technological and other developments. So all of the data and information that was shared on these slides is freely accessible through the eTrips gateway at etrips.wto.org. Should you have any questions, we would be pleased to hear from you at etrips@wto.org. Thank you.
Thank you very much, Natalie. I think this is a powerful, brief but powerful snapshot of what the eTrips system can do and how it, in a way, unlocks the information that this enormous amount of information that is submitted to the TRIPS Council every year in those notifications. But I think the graphs also show very nicely the wave of legislative activity, which of course is only the visible part of domestic efforts in members to overhaul their IP system. There is of course a lot more than simply passing laws that goes into these implementation efforts. I think it was also clear to see that, of course, after the initial effort when joining the WTO, or when TRIPS became applicable to these countries, has now given way to a picture that the transparency provisions provide of the ongoing efforts and activities of members as they amend their IP regime, their legal regime governing intellectual property, to technological challenges, to other developments, some of which we will highlight, in fact, in this afternoon's session. But I think another aspect in which the ongoing interaction and the ongoing interest of WTO members in IP policy is evidenced is not only that they put IP policy discussions on the agenda of the TRIPS Council, as the current TRIPS chair has highlighted. IP and innovation, IP and the public interest are almost regularly now requested as items on the TRIPS Council agenda, but also the lively discussions and quite in-depth technical discussions that members have on IP questions and IP implementations in the context of trade policy reviews. As you know, the trade policy review mechanism reviews members' trade policies from a Secretariat perspective, but also from their own perspective, with a certain periodicity depending on the level of development of members. This quite effort-intensive work on the part both of the Secretariat and the members results in quite a detailed overview of policies in different fields, including in the area of intellectual property. And I'm glad to hand over now to my colleague Josefita Pardo de Leon, who's a legal affairs officer in our division, and part of whose responsibility are the monitoring efforts of the Secretariat and the monitoring of the trade policy reviews, to which we also sometimes contribute. She will give us an overview of what we can learn from trade policy reviews and the IP issues that are raised there, that very often inform where the interests of members currently lie and what are the salient questions of TRIPS implementation today in the face of developmental or technological challenges. So, Josefita, I'm happy to hand over to you.
Greetings, I am Josefita Pardo de Leon, and I have the pleasure to join you today to look at the TRIPS agreement from the perspective of members' trade policy reviews. Please allow me to start by providing an overview of the trade policy review mechanism. The trade policy review mechanism was an early harvest of the Uruguay round. It was provisionally established at the Montreal Midterm Review in December 1988. At that point in time, it covered only trade in goods. This shows that the GATT contracting parties were already regarding transparency as an essential pillar of the rules-based trading system. The first trade policy reviews were those of Australia, Morocco, and the United States. In 1994, the trade policy review mechanism was incorporated into Annex 3 to the agreement establishing the World Trade Organization. With the entry into force of the WTO agreements in 1995, amongst them, of course, the TRIPS agreement, the mandate of the trade policy review mechanism was expanded to cover trading services and intellectual property. The overall objective of the trade policy review mechanism is to facilitate the smooth functioning of the trading system by enhancing transparency. It is a process of multilateral peer review of domestic trade policies covering goods, services, and intellectual property, and at the same time, the process considers the overall economic context of the member on the review. All WTO members are subject to trade policy reviews. Since 1995, 157 members out of 164 have been reviewed, and the Secretariat has issued more than 500 trade policy review reports. In these reports, more than 6,800 paragraphs contain information on intellectual property. Currently, the 4 members with the largest shares of world trade, the European Union, the United States, Japan, and China, are reviewed every 3 years. The next 16 members are reviewed every 5 years, and others every 7 years. A longer period may be envisaged for the reviews of least developed country members. The implementation of the TRIPS agreement by members has been charted in trade policy reviews. Over the last 25 years, the coverage of TRIPS-related issues has grown to reflect the evolution of national and regional intellectual property systems and how they have become an integral part of national development policies aimed at fostering research and innovation, promoting exports, attracting foreign direct investment, participating in global value chains, and overall improvement of competitiveness. We have also witnessed how both developed and developing country members have registered their interest in the role that the intellectual property regime plays in trade policy and economic development. During trade policy reviews, delegations are increasingly taking the opportunity provided by each review to ask specific questions. This chart shows you the issues raised by members in their questions in 2018 and 2019. There were 224 questions related to copyrights, followed by 190 questions on patent-related issues. Overall, these questions relate, for example, to recently enacted laws or legislative reforms aiming at modernizing the intellectual property regime so that it can nimbly respond to technological evolution and new ways of doing business, coherently implementing obligations under the TRIPS agreement, WIPO instruments and free trade agreements, modernize institutions and procedures for the administration of intellectual property rights. Intellectual property regimes are living organisms, constantly evolving to respond to new challenges and opportunities. Lately, interested members are also seeking specific information regarding copyrights and related rights in the digital environment, registration of holograms, color marks, sound marks, and position marks, geographical indications for non-agricultural products, patent quality, protection of trade secrets, protection of the collective knowledge of indigenous peoples related to biodiversity, TRIPS and competition policy, enforcement online and at the border, and valuation and composition of assets related to intellectual property. Members are also keenly interested in the intellectual property component of national development policies designed to support, for example, micro, small, and medium enterprises, environmentally friendly innovation, and women entrepreneurs. In the responses to those questions, the member on the review provides detailed information about its intellectual property regime and its role in the domestic economy. This dialogue contains a wealth of information for policymakers, trade negotiators, and academics. It is public information available on the minutes of each trade policy review. Looking at the future, the discussions sparked by the questions during trade policy reviews result in positive exchanges that track the evolution of the implementation of the TRIPS agreement all over the world. They provide a detailed picture on the way intellectual property is being mainstreamed into trade and economic policies, as well as other policies such as agriculture and public health. They also provide useful insights into the policy choices and actual experiences of the member under review. From these informations, other members can build best practices based on real-life examples. Thank you very much for your kind attention.
Thank you very much, Josefita. This is an excellent overview. I think it illustrates the point that Tony was making before, that TRIPS is not only an agreement that sets out obligations, but it can also be a forum for discussion and exchange, policy debate. You've highlighted a part of the policy debate that is taking place under the trade policy reviews. But as the chair mentioned, the TRIPS Council's agenda also has a number of review items that could easily be populated with precisely those exchanges and discussions that members are having in the wake of individual trade policy reviews. Let me now turn to our next topic, which highlights an ongoing area of activity of the TRIPS community, which is the technology transfer element of our work. As you know, the TRIPS founders not only recognized that the value of setting minimum standards for IP protection and enforcement, they also acknowledged that technology transfer was part of the intended consequences of IP protection. And in Article 66.2, provided an obligation for members, for developed country members, to provide an incentive for technology transfer to least developed countries. I'm happy now to give the floor to Ms. Wu Xiaoping, a counselor in the IP in our division, who's been responsible for a number of years now for the implementation and the discussions around Article 66.2 and the Secretariat's support for this work among members. And she will give you an overview on the lessons from the implementation of Article 66.2 in the past 25 years. Xiaoping, the floor is yours.
Everyone, my name is Xiaoping Wu, and I'm a counselor at the Intellectual Property, Government Procurement, and Competition Division here in WTO. It's a great pleasure to join my colleagues today in reflecting on the legal and institutional impact of the TRIPS agreement on the global and the national IP system. Today, my reflection will be focused on the implementation of Article 66.2 of the TRIPS agreement. This article specifically obligates the developed country members to provide incentives to enterprises and institutions in their territory with the purpose to promote and encourage technology transfer to least developed country members and to enable the least developed country members to create a sound and a viable technological base. I will first present a factual overview of Article 66.2 negotiation and its implementation over the past 25 years. And will share with you my reflections on the lessons that could be learned from the past experience. I will then introduce the issues that are still under discussion, as well as my thoughts on how these issues could be addressed in the future. Before I start my presentation, I would like to take this opportunity to acknowledge the contribution of my former colleague, Ms. Jeffrey Wattle, and her work on this subject over the past 16 years. Just before her retirement, she co-authored with a young professional, Ldc Caminero, a staff working paper on this topic. This paper provides a detailed and first-hand negotiating background of Article 66.2, in addition to its implementation from 1996 to 2016. Today's presentation has been built on their professional research and thoughtful suggestions. First, let me present a brief overview of the negotiation and implementation of Article 66.2 over the past years. During the TRIPS negotiations, Bangladesh, on behalf of the LDC group, made it very clear that the future agreement should contain provisions relating to the improved access to and the effective transfer of technologies. This task, together with two other tasks, one is a technical cooperation and the other is a long transition period, was accepted by the TRIPS negotiators and eventually led to the incorporation of Article 66.2 into the TRIPS agreement. In 1997, 2 years after the TRIPS agreement coming forth, Bangladesh raised the issue of Article 66.2 implementation in the TRIPS Council's meeting for the first time. It's only since then the Council has started its review process. In 2001, as requested by the LDC group, members agreed to establish a reporting and review mechanism to ensure the full implementation of Article 66.2 obligation. In 2003, the TRIPS Council adopted a decision on the Article 66.2 implementation. The decision provides detailed requirements for the information that developed country members should present in their annual reports for the TRIPS Council's review. Since 1998, the Council has received 337 reports from the developed country members, among which 291 reports were submitted under the reporting and review mechanism adopted in 2003. The Council has conducted 17 annual reviews of these reports. These reports produced a significant amount of the information from developed country members' various government agencies. In 2011, in order to better understand this information, the LDC group made a proposal regarding the reporting format. The proposed format has been utilized by some reporting members. Others have also improved their reports by considering elements contained in the proposed format. Now, let me talk about what lesson could be learned from this past experience. Looking back over the past 25 years, one lesson that could be learned is the LDC's active engagement in the negotiations and the developed country members' positive responses to LDC's concern were totally indispensable for the conclusion of Article 66.2, adoption of the 2003 decision, as well as the following annual reports submitted by the developed country members. This active engagement, positive responses were driven by members' willingness to listen to each other, their mutual respect, and their negotiating skills. These are all essential ingredients that led to the success of the TRIPS agreement and its implementation. Now, let me move to the second part of my reflection. What are the remaining issues? Despite of previously mentioned accomplishments, as we know, the LDCs still have the question of whether the developed countries are meeting their obligation and whether the 2003 reporting and review mechanism is effective enough in monitoring the implementation of this obligation. In particular, there are two substantive issues and one procedure issue which have been constantly raised by members in the TRIPS Council's discussion. The substantive issues are the lack of the common understanding of the concept of technology transfer and the concept of incentive. And the procedure issue is what format or template should be used by developed country members to present their annual reports. Now, I would like to share with you my thoughts on how these issues could be addressed in the future. Regarding the substantive issues, first, it should be noted there's no common understanding of these concepts even among the reporting countries, not to mention between the reporting countries and LDCs. However, there are several elements in these concepts which are part of the shared understanding of the members. Members may wish to focus on these common elements which can constitute a starting point for future discussion. For example, over the past years, the LDCs made some positive feedback on the incentives mentioned in Article 66.2 reports and proposed an illustrative list of incentives in a room document in 2018. Secondly, in addition to discussing these relatively abstract concepts, members may investigate actual and concrete incentives and technology transfer projects presented in Article 66.2 reports, particularly those they believe go in the right direction and can be a good model for the future reports. Thirdly, it seems natural for the LDCs to identify areas of priority for technology development, which will best satisfy their development needs. This is because the purpose of Article 66.2 obligation is to enable LDCs to create their sound and viable technological base. This self-identified technological priority could help developed country members in carrying out their obligation more effectively. Regarding the reporting format issue, as noted by the LDC group, various formats have been utilized by the reporting countries, including the 2003 decision, the format proposed by LDC group in 2011, based on which the current e-trip submission system was developed, and the format proposed by the LDC group in 2020. In my very humble view, there's no substantive differences between the information required by the LDC group in its proposed formats and the information required by the 2003 decision. As pointed by the LDC group, the new format was aimed to simplify the reporting process, coordinating the current reporting formats, and acknowledging the substantive contributions of developed country members. On this issue, the reporting countries and LDCs do have a common interest. A well-designed reporting format will facilitate the reporting countries collecting and collating the vast amount of the information, and will also facilitate the LDCs absorbing and analyzing this information. Therefore, the LDC group and the group of the reporting countries should be able to find a win-win solution. We in the WTO Secretariat are committed to assisting both the LDC members and the reporting members in the Article 66.2 implementation. We are committed to helping the LDC members understand the annual reports and assess their priority needs in different areas of technologies. We are also committed to helping the reporting members make effective use of the transparency mechanism. For example, at the request of the LDC group, the Secretariat has organized a series of annual workshops since 2008. These workshops are intended to enable informal dialogues between the delegates from the reporting members and the LDC members. Last year, as part of the effort to improve the value and impact of these dialogues, we invited capital-based experts from the LDCs who had a direct responsibility for technology transfer. We asked them to present the current area of priority for technology development. We also asked them to present the projects which are relevant to this priority area and to share their experience. I believe this exercise has been appreciated by both LDC's members and the reporting members. Now, let me end by saying that WTO is a member-driven organization, and thus the discussion on both substantive and procedure issues will be guided by WTO members. I would like to thank you again for this opportunity to share with you my reflections on this subject. And I hope these reflections will provoke members' thought on the subject in the future. Thank you very much.
Thank you very much, Xiaoping, for this comprehensive overview of this indeed complex issue, technology transfer under Article 66.2, and for your personal reflections on and thoughts in this regard, which I'm sure viewers will find helpful. Moving on in the program, let me now move to the issue of TRIPS capacity building. You will know, and it's been mentioned before, that the TRIPS negotiators again provided an ongoing obligation to members for developed country members to provide technical assistance for the implementation of the TRIPS agreement. This, of course, goes hand in hand with the technical assistance that the Secretariat itself has been providing. And it's an essential part of the WIPO-WTO agreement that was mentioned a couple of times already today to provide such Secretariat-led technical assistance and capacity building. And in fact, that was done in consultation with WIPO, both initially for the entry into force of TRIPS for developing countries when their deadline came up, for implementing and applying the TRIPS agreement, and continues this cooperation in particular with regard to LDCs and acceding countries that get ready to follow the standards in the TRIPS agreement. But to give an overview of the information that we have about technical assistance, and let me just highlight that the reporting practice in the TRIPS Council actually gives us an annual overview of all global technical assistance with regard to TRIPS every year. Quite a unique set of information, I think. I would like to hand over to Megan McGann, who is the Legal Affairs and Technical Assistance Officer in the TRIPS division, and who's best placed, of course, to give us an overview on Article 67 and how it's providing a global landscape of technical assistance in the context of TRIPS capacity building. Megan, the floor is yours.
This is a presentation on TRIPS capacity building, and in particular, Article 67 of the TRIPS agreement as providing a global overview of IP-related technical assistance. I'd like to start this presentation with a question. Why does the TRIPS agreement even include a provision on technical assistance? And to get to the answer, I think it helps to look at the big picture perspective and turn to the agreement establishing the WTO in the first place. In the preamble to the agreement establishing the WTO, members in fact recognize the need to take action to help ensure that developing country members and least developed country members would be able to increase their participation and their share in world trade and the multilateral trading system. And across the different WTO agreements, you can see illustrations of this in the form of references to technical assistance. And indeed, the TRIPS agreement in Article 67 is one such illustration of this recognition. Now, Article 67 of the TRIPS agreement requires developed country members to provide, on request and mutually agreed terms, technical assistance on IP-related matters, including protection and enforcement. And they're required to provide this assistance to developing country members and least developed country members. One way to help operationalize this obligation was the idea to establish contact points. So developed country members agreed that they would notify to the TRIPS Council contact details of the relevant office or ministry, or even the name of a person that could help coordinate IP-related technical assistance. In addition, WTO members also agreed to establish a reporting mechanism in relation to IP-related technical assistance and Article 67 of the TRIPS agreement. And what this reporting mechanism looks like is each year developed country members provide to the TRIPS Council descriptions of their different IP-related technical assistance projects and programs. And to help with transparency and to help disseminate information on all of the IP capacity building efforts that go on worldwide, the TRIPS Council in general invites intergovernmental organizations also to describe their IP-related capacity building activities. And in doing so, the TRIPS Council and the WTO really has a unique view of IP capacity building all around the world. So what do things look like today in 2020, after 25 years of the TRIPS agreement? Well, in the short amount of time I have, I'll just give some very sparse facts, but they still tell a very impressive story. So for example, in 2020, there were projects and programs benefiting over 148 WTO members and observers. And in the reports for the year of 2020, there were over 190 different projects and programs described. And these projects and programs targeted all regions of the world. And in addition to this, these projects and programs on technical assistance target a wide variety of different participants, including policymakers, parliamentarians, IP examiners, the judiciary, police, the scholarly community, customs officials, and more. But what is really interesting is to look at how IP-related technical assistance has evolved over the past 25 years since the TRIPS agreement. And when you look at these reports, in fact, what you see is that based on the needs of the beneficiary members and then the corresponding technical assistance provided, it becomes clear that IP systems have been regarded as dynamic systems, almost as living things. And so, like living things, IP systems require attention so that they can both help shape the economic environment and can also adapt to rapidly changing times. In the beginning, in the early years following the entry into force of the TRIPS agreement, the type of IP technical assistance that one could see was more so focused on what can be described as putting down the roots. So really in building IP institutions and enacting IP laws. So as a concrete example, one report from 1996 described one of its projects as reviewing draft IP laws of another member in order to provide comments and advice on the consistency of those IP laws with international treaty obligations. And over time, you can see the focus shift less from strictly building institutions and assisting members with the drafting and creation of IP laws to assistance that branches out to get to cross-cutting IP-related policy issues. And a concrete example of this can be seen in the reports from just this year. So for example, in one report, a member provided training to government officials in many different ministries, those dealing with agriculture, with investment, with economic affairs. They provided training to officials so so that officials could then help their small and medium-sized enterprises in their jurisdiction increase their competitiveness in the food and spice sector. So again, here's an example of technical assistance to get at a policy question. How do we help small and medium-sized enterprises in a specific sector, best take advantage of IP systems so as to increase their competitiveness, both at home and in foreign markets? Now, I think a common thread that you can see over the past 25 years, despite the evolution from more so focus on legislation creation to looking at policy questions, is that throughout time, the systems have still required maintenance, just like a living thing. They require attention to make sure that the IP institutions remain robust and responsive to the changing times. And so technical assistance has also been provided along those lines as well throughout the past 25 years. And one concrete example of this is one member provided training to patent examiners in the fields of biotechnology, genetic resources, and computer implemented technology. So 3 fields that have seen revolutionary changes in the past 25 years. So in other words, we're still seeing assistance that helps go towards making the institutions, IP laws, IP systems adaptable, and also helping those systems shape the economic environment. Now, thus far, I've mostly been speaking about IP-related technical assistance as provided by WTO members to other WTO members. But indeed, providing technical assistance is one of the main functions of the World Trade Organization and one of the main activities carried out by its Secretariat. And the story of WTO technical assistance follows a very similar narrative as the technical assistance provided by WTO members. In that, over the past 25 years, it's evolved to be increasingly thematic, increasingly holistic, and really always staying demand-driven. And one of the best examples of this is the WTO workshop on trade and public health. And this workshop has been running for 15 different editions, and it focuses on the interaction of health, trade, and intellectual property policy. And participants are government officials from the different ministries. And the aim of this is to really take the approach from a holistic manner and help foster a coherent strategy to IP, health, and trade policy making. And of course, it would be remiss to make it seem as if the WTO does all these things by itself. Of course, we do not. We work very closely with partner institutions in the design and delivery of technical assistance. For example, we work very closely with the World Intellectual Property Organization in our technical assistance activities, and also a number of other stakeholders, including the World Health Organization, for example, also the United Nations Conference on Trade and Development. And that's just naming a few. Of course, we work with many diverse stakeholders. With that, I would thank you for your kind attention to this presentation on TRIPS capacity building.
Thank you very much, Megan. I'd like to echo that last point that Megan made, in particular, the broadening of capacity building and technical assistance, both what is provided by members, but also what we as the Secretariat are asked for. Megan has mentioned, of course, trade and public health, IP and public health as being one of the most popular cross-cutting issues for which we get requests, but we have also increasingly received requests from members for technical assistance activities on TRIPS and climate change, TRIPS and e-commerce, and similar activities for which we often are happy to cooperate with our colleagues from other divisions of the Secretariat, and of course also with other international organizations, as mentioned. Another side effect of this is in fact that while true to the original intention of capacity building, our funding is mostly focused on providing technical capacity to developing country participants. In some of our flagship activities, we've increasingly have demands from delegates or other representatives of developed countries to also participate in these events. I think this reflects that the salient questions more and more today have, I think, moved on from institution building and building up the plumbing, so to speak, of the IP system to the consideration of cross-cutting policy issues in the area of health, of climate change, and other considerations. And I think we will hear this afternoon the salient issues of our time in the area of developments of the digital landscape and new technologies and innovation policy. Let me now move to the next theme, and of course our overview of the legal impact and the institutional development of the TRIPS agreement would not be complete without looking at the development of the agreement itself. As you know, and as DDGE has mentioned, TRIPS was the first agreement to have been amended, and you know that amending international agreements is not an easy feat. To provide an overview of the context and the background within which this amendment took place, and in fact the larger backdrop of the Doha Development Agenda, the public health dimension, and the subsequent cooperation to which that has led, I'm very happy now to hand over to my colleague Roger Kampf, who's been leading the division's work on health for a number of years and is well known to many of you. And he will speak on the evolution of the TRIPS agreement in this context. Roger, you have the floor.
I'm pleased to speak to the evolution of the TRIPS agreement as it relates to public health. I will address experiences and lessons learned from TRIPS implementation and look at the evolution in three areas: the legal framework, cooperation, and capacity building. To conclude, I will share some personal thoughts about the way forward. By way of introduction, let me set out why addressing TRIPS and public health means working in a complex environment. As shown by this bubble chart, a wide range of law and policy dimensions impact the innovation and access cycle in the pharmaceutical sector and need to come together. Those include affordability and pricing policies, regulation to ensure quality, safety, and efficacy, innovation policy, various elements of the IP system, international trade agreements, tariffs and non-tariff measures, as well as competition and procurement policies. Ensuring policy coherence also requires bringing together different actors that operate within the multilateral, regional, and domestic frameworks. Key actors include intergovernmental organizations, regional organizations, governments, the private sector, and civil society. Relevant frameworks are determined by multilateral agencies, including WHO, WIPO, and the WTO, regional organizations, trade and investment agreements, and last but not least, domestic factors, such as the national IP, policy and strategy, legislation, and jurisprudence. Since the beginning, three questions have accompanied the debate about the link between public health, IPRs, and trade. First, how best to reconcile the need for incentives to invest in R&D and access to medicines. Second, how best to achieve an optimal balance between IPRs and public health. And finally, how best to ensure capacity to deal with the innovation access cycle in a holistic manner. Let me now turn to the theme of this presentation, i.e. the interface between TRIPS and public health, and how the evolution of the TRIPS agreement has responded to these challenging questions. To do so, I will first look at the evolution of the legal framework, namely the Doha Declaration and subsequent instrument. They have affirmed the capacity of the TRIPS agreement to respond to pressing needs and to place it into the broader picture. To refresh our memories, why was there even a need to adopt the Doha Declaration? To answer this question, we need to bear in mind the context in which the declaration was drafted and adopted, and in particular, the HIV/AIDS crisis that was afflicting African countries in the late 1990s, as well as the deadline for the implementation of the TRIPS agreement by developing countries in 2000. The purpose of the declaration was to respond to concerns about the impacts of TRIPS protection and enforcement standards in the pharmaceutical sector on access to affordable medicines. The importance of adopting the declaration can be explained by three factors in particular: divergent views about the nature and scope of TRIPS flexibilities, whether those flexibilities could be interpreted in a pro-public health manner, and finally, how to deal with pressure from trading partners to forego the use of existing flexibilities. In response to those concerns, the adoption of the Doha Declaration represented a blueprint for policy coherence because, one, it was trade ministers who recognized the gravity of public health problems, and two, they called for the TRIPS agreement to be part of the wider national and international action. Among the main achievements of the Doha Declaration are the creation of a solid basis for multilateral cooperation, the clarification of TRIPS flexibilities regarding compulsory licenses and the exhaustion regime, the support of governments to make use of existing flexibilities, the addition of new flexibilities, including a trade-related compulsory license for export and extended transition periods for least developed countries, and finally, the guidance it has provided to subsequent dispute settlement cases. Let us now look at those achievements from a practical perspective, starting with compulsory licenses under Article 31 of the TRIPS agreement. According to a WIPO draft reference document published in 2019, 156 jurisdictions include provisions governing the grant of compulsory licenses and government use licenses. The draft reference document notes that the use of compulsory and government use licenses has initially been limited in most jurisdictions. However, an increased use in relation to pharmaceutical patents could be observed since 2010. As shown in the table on this slide, the trilateral study analyzes 34 selected cases in which compulsory licenses and government use licenses have either been considered or granted. Other sources report 108 instances since 2001 in which 74 compulsory or government use licenses have been granted. In addition to clarifying existing flexibilities, the declaration has also created new flexibilities, including a trade-related compulsory license for export. The declaration identified difficulties for members with insufficient or no manufacturing capacities in the pharmaceutical sector to make effective use of compulsory licenses, caused by the restrictive conditions in Article 31F, according to which production under compulsory license must be predominantly for the supply of the domestic market. The concern was that this could constitute a barrier for countries with manufacturing capacity to export medicines. In response, derogations from restrictive conditions in Article 31F and H were adopted, thus addressing a health problem in the importing member and a legal problem in the exporting member. Steps towards putting the system in place culminated in the entry into force of the amended TRIPS agreement in 2017. At the extraordinary meeting of the TRIPS Council on 30th January 2017, members welcomed the entry into force as a significant step and truly historic measure, providing legal certainty to access affordable medicines. They also noted the importance of the new flexibility because it flagged the WTO's capacity to respond to pressing needs beyond trade liberalization. The second flexibility concerns least developed countries. As part of the Doha Declaration, members also agreed to exempt least developed countries with respect to pharmaceutical products from the obligation to protect patents and undisclosed information, including test data. The initial transition period was subsequently extended and currently runs until 2033. The second example regards the evolution from working in silos to an inclusive approach, bringing on board the respective expertise of a maximum of relevant actors. The cooperation with external partners has considerably intensified since the adoption of the Doha Declaration. Indeed, we look back at more than 10 years of close trilateral cooperation, pulling together the expertise of WHO, WIPO, and the WTO. In addition, the three organizations have reached out to other IGOs and key stakeholders to make the cooperation as inclusive as possible. For this cooperation to be effective, it is necessary to be mirrored at domestic level. Reports from member representatives witness good progress, indicating that cooperation among different government departments is becoming the rule rather than the exception. There has also been a significant evolution regarding the cooperation on health-related matters within the WTO Secretariat. While in the past working in silos has been more common, collaboration among divisions has considerably intensified over the last decade, recently culminating in the establishment of the COVID-19 Trade Monitoring Group. This evolution has taken place in parallel with important developments in and outside the WTO, such as the adoption of the Doha Declaration, the WIPO Development Agenda, and the WHO Global Strategy and Plan of Action, as well as enhanced trilateral cooperation. COVID-19 related work is exemplifying joint Secretariat efforts to ensure transparency and to build capacity to effectively address the pandemic. The COVID-19 webpage offers important resources, including regularly updated lists of measures taken by governments in the field of goods, services, and IP, a series of information notes, including on the TRIPS agreement and COVID-19, and most recently, a vaccines checklist of issues with trade impact and a related infographic. The third and last example relates to capacity building and in particular, the evolution towards an integrated and more tailored approach based on close cooperation and empirical data to support informed decision-making. Perhaps the best illustration of this evolution is the WTO Secretariat's annual Trade and Public Health Workshop. Organized since 2005, it has initially focused on this intersection between IP and health. Since 2014, it has adopted an integrated approach, looking at the health, IP, and trade dimensions in a comprehensive manner. Another recent example for the integrated approach is the WTO technical workshop that has been organized by the Secretariat in cooperation with WHO and WIPO secretariats to help members address the COVID-19 pandemic. And last but not least, the revision and update of the trilateral study on promoting access to medical technologies and innovation and the launch of its second edition last July is another milestone on the path towards an integrated approach. Cooperation with WHO and WIPO secretariats has focused on gathering empirical data to support policymakers in taking the right decisions. In particular, the 2015 Symposium on Innovation and Access to Medicines, Learning from the Past, Illuminating the Future, highlighted the need for factual information and has initiated more intensive work in this regard. To conclude, I would like to share some personal thoughts regarding the way forward. Those represent my own views and cannot be attributed to the WTO Secretariat. Let's first take stock. A number of positive developments can be attributed to TRIPS implementation, such as the capacity of the agreement and the membership to respond to pressing public health needs. The recognition that TRIPS needs to be placed into the broader context, accompanied by the development from an IP-focused perspective to an approach integrating other policy dimensions. Enhanced cooperation with key external stakeholders and within the Secretariat that is mirrored by comparable developments at domestic level. The demonstration of a possible positive sum impact of working within the existing framework, most recently illustrated by the development of COVID-19 vaccines within record time. 10 vaccine candidates have entered phase 3 of clinical trials within less than 1 year, and 1 vaccine has been submitted for emergency use approval last week. And the observation that legislation is not static, but is subject to constant review, as confirmed, for example, by the streamlining of compulsory licensing provision in certain members to address the COVID-19 pandemic. What lessons can we draw from the experience so far and what is needed for the future? First, there's clearly a need for more empirical data and evidence to support informed decision-making. Second, the development of more tailored assistance, technical assistance, including protection standards and policy options in all intellectual property rights relevant to public health, is a must to effectively respond to the specific needs of members. Third, there is clearly demand for more transparency, in particular as regards easy access to patent information. In the context of the current pandemic, this may also entail the need for patent landscape reports to help secure equitable access to vaccines around the world. Fourth, the integrated approach must be further developed, including a number of key policy areas listed on the slide. And finally, one might ask whether a Doha Declaration 2.0 could usefully complement these action points. For example, it could address uncertainties about the scope of the special compulsory licensing system. It could also clarify certain flexibilities in IP categories other than patents that could be relevant to public health. Thank you very much for your attention and stay healthy.
Thank you very much, Roger, for this comprehensive overview and the journey of the TRIPS amendment and also the broader platform for cooperation that the Doha Declaration has provided, including also mapping the Secretariat's activities in response to these cross-cutting questions. I will now move to our next speaker, who will address another important and cross-cutting topic that relates to the TRIPS agreement. The TRIPS agreement's impact and institutional impact is, of course, not only felt within the TRIPS Council. One very important aspect of the WTO structure is the dispute settlement system. Now, WTO disputes relating to the TRIPS agreement are not the majority of WTO disputes. I think it's well below 10% of WTO disputes have a TRIPS aspect. But the cases that members have decided to pursue all the way into the WTO dispute settlement often are significant milestones for domestic IP policy and for questions what type of implementations that are developed in the face of particular challenges, how they sit with the standards described in the TRIPS agreement. So I'm happy to hand over to Hannu Vaga, who was mentioned already by Stuart Harbinson, one of the most senior members of the TRIPS division, and one of my predecessors as Secretary of the TRIPS Council for quite a number of years. Hannu will speak to us on 25 years of policy insights from TRIPS-related WTO disputes. It's my pleasure to give you the floor, Hannu.
Thank you, Wolf. One of the objectives of the TRIPS agreement, as stated in its preamble, is to reduce tensions in international trade relations by reaching strengthened commitments to resolve IP issues through multilateral procedures. The agreement does this by making TRIPS subject to the overall WTO dispute settlement system. This system, in turn, was designed to provide security and predictability to the multilateral trading system and to clarify the existing provisions in accordance with customary rules of interpretation of public international law. The question I will attempt to answer is, how has the WTO dispute settlement system operated in the area of TRIPS over the past 25 years, and what policy insights can we draw from its operation? I would suggest that overall the system has worked well in this area. It has resulted in a comprehensive and balanced body of TRIPS jurisprudence, which is coherent vis-à-vis both the wider corpus of international IP law and the rest of WTO law. This jurisprudence has positively informed members' domestic policies, notably relating to public health. Having provided my conclusions up front, I will now elaborate why I think this is the case. I will first review the use of the system in the area of TRIPS, then give some illustrations of the policy guidance we can draw from it, and then discuss how the system has sought to ensure coherence. To date, a total of 42 requests for consultations under the dispute settlement system have included one or more claims under the TRIPS agreement. Throughout the past 25 years, the share of such requests has remained steadily at around 7% of all the requests for consultations, currently numbering 597. While this is by no means a paltry number, it however shows that there has been no flood of TRIPS litigation, as was feared by some participants in the Uruguay round negotiations. A related concern that also has not materialized was that members found to be in breach of their TRIPS commitments would put their market access rights in jeopardy through the so-called cross-retaliation. In fact, this has not happened a single time. Overall, cross-retaliation has been authorized under the WTO only 3 times. In each case, the violation took place either under the technical nature of some of these disputes. Some early settlements also illustrated members' preference to find solutions through political engagement and technical cooperation. Another distinctive trend in TRIPS disputes has been that out of the 14 panel reports issued to date, only 6 have been appealed to the appellate body. The reason might be that a number of reports looked at 2 or more measures. In these cases, both the complainants and respondents won on certain points of importance to them. That may imply that the parties found the overall balance of interests acceptable to them and therefore were reluctant to risk that balance on appeal. The low appeal rate also reinforces the impression that these panel rulings were not perceived as particularly controversial or far-reaching. A general lesson that might be taken from our experience so far is that the possibility of using intergovernmental dispute settlement procedures to litigate IP issues does not necessarily translate into a high number of formal invocations of such disputes. It appears that governments may wish to prioritize long-term political engagement and technical cooperation with their partners. This may have a potentially moderating effect on the use of the dispute settlement system. Governments may also exhibit a degree of restraint in challenging the regulatory space on which some of their own regulatory measures may depend. Let me now give you some illustrations on how TRIPS jurisprudence has informed members' domestic policy. Cases that arguably have had most important long-term systemic implications on members' domestic policies are those that have explored the scope of permissible exceptions to IP rights and therefore the balance found in the agreement. For example, the scope of permissible exceptions to patents and copyrights is determined by the so-called three-step tests, which are contained in Articles 30 and 13, respectively. The panel report in Canada Pharmaceutical Patents examined the intersection between TRIPS and public health. On one hand, the panel found that Canada's regulatory review exception met the conditions of the three-step test in Article 30. On the other, the panel found that the more far-reaching stockpiling exception did not meet those conditions. Also, the report in US Copyright Act examined two exceptions, this time on copyright. The panel found that the narrowly defined home-style exception met the conditions of the three-step test in Article 13, but the broader business exception did not. There was a certain symmetry between these two cases, because both of them required panels to interpret similar three-step tests and then apply that general analysis to a fact pattern that involved one truly limited exception and another more expansive one that ate into a more significant portion of what were seen as legitimate forms of exploitation of IP rights. Both rulings have provided important guidance on WTO members' implementation and policy discussions at the WTO and other forums. Since the adoption of the report of Canada Pharmaceutical Patents in 2000, a number of members have implemented regulatory review exceptions in their domestic laws, including the member that had brought that case. At the TRIPS Council meeting held in February 2018, delegations shared their experience regarding the implementation of such exceptions in their own domestic laws. Similarly, the report on US Copyright Act has been frequently referred to in discussions on permissible copyright limitations and exceptions at the WTO, WIPO, and beyond. The recent reports in Australia tobacco plain packaging also examined the intersection between IP and public health. 5 members challenged Australia's tobacco plain packaging measures. The objective of these measures was to improve public health by reducing the use of tobacco products. The complainant challenged the TPP measures as being unnecessary within the meaning of Article 2.2 of the Agreement on Technical Barriers to Trade and unjustifiable within the meaning of TRIPS Article 20. The complainants did not dispute the harmful consequences of tobacco consumption. They argued instead that the TPP measures were not capable of contributing to their public health objective. The panel examined an extensive amount of evidence provided by the parties. It concluded that the TPP measures as applied in combination with other tobacco control measures maintained by Australia, are capable of contributing and do in fact contribute to the objective of improving public health by reducing the use of tobacco products. The panel then weighed and balanced various relevant considerations and found that the complainants had not demonstrated that the TPP measures were inconsistent with these provisions. 2 complainants appealed these findings. The appellate body upheld the panel's overall conclusions under these provisions. The complainants also claimed that the TPP restrictions on the use of figurative elements of trademarks and GIs were contrary to a number of other TRIPS provisions. The panel found that the complainants had not demonstrated this to be the case. These conclusions were appealed only in respect of 1 provision, and the appellate body upheld them. Tobacco plain packaging and other tobacco control measures were also discussed at 9 TRIPS Council meetings from 2011 to 2015. At that time, a number of other members were in process of preparing or considering similar measures. Since the Australian TPP measures were passed in 2011, some 16 other WTO members have introduced similar measures. 12 of them did so since the circulation of the panel reports. A number of other members have already passed similar measures, but they have not yet entered into force. Furthermore, several other countries are currently considering such measures. Let me finally turn to coherence. One factor that has contributed to the development of a coherent body of jurisprudence has been the systemic approach to interpretation followed by WTO panels in the context of IP cases. Panels have consistently interpreted TRIPS provisions by employing the presumption against conflict vis-à-vis other international IP conventions. As the early panel in US Copyright Act noted, one should avoid interpreting the TRIPS agreement to mean something different than the Berne Convention, except where this is explicitly provided for. More recently, the panel in Australia Tobacco Plain Packaging observed that this statement applies equally to the interpretation of the provisions of the Paris Convention as incorporated into the TRIPS agreement. In all cases where provisions of the Berne or Paris Convention have been invoked, panels have sought and obtained factual background information from WIPO on the drafting history and subsequent practice relating to those provisions. This information has helped panels to ensure coherent interpretations within this wider framework of international IP law. Another factor that merits highlighting is how IP panels have generally sought to make rulings that were narrowly tailored to what was necessary to decide to dispose of the case at hand. In conclusion, let me say that in my view, our experience in TRIPS dispute settlement from the past 25 years provides a good foundation for our future efforts to maintain security and predictability in international IP relations. The challenge before us is to continue to seek positive solutions to TRIPS disputes brought before the system in a way that is well informed and sensitive to the specificities of the multilateral IP law and also coherent with the rest of the WTO.
Thank you, Hanu, for this thoughts and observations on the policy implications of TRIPS-related WTO disputes and on the structural aspects of coherence and the systemic approach the panels have taken in these questions. We're coming up towards the end of our morning session, and I'm very happy to take the very last slot of today's session to look a little bit at how TRIPS relates to other international agreements. Like my colleagues, I've recorded this intervention before, and I would like to ask my colleagues to stream it now. So I have the honor to give the floor to myself for this last presentation. I want to use this short session to talk about the relationship of the TRIPS agreement to other international treaties and bilateral treaties, and on how, in some instances, it has served as a benchmark for norm setting in these other international instruments. Now, we know that the TRIPS agreement achieves its coherence with the international IP system in a number of ways. There is what I would call upstream coherence, which is achieved by basing itself and incorporating, in large parts, pre-existing WIPO conventions and treaties. You know that this reflects, of course, the fact that the negotiators of the TRIPS agreement did not want to reopen the basic elements of the Paris Convention or the Bern Convention, or the elements from the Rome Convention and the Washington Treaty on Integrated Circuits that had already been negotiated and in some cases entered into force in the context of the World Intellectual Property Organization. So including those and incorporating those in TRIPS provided that the TRIPS agreement was coherent with that previously agreed level of intellectual property rules. Now, downstream coherence, so coherence with subsequent international treaties, is of course equally important. And I want to highlight in this short session two elements in this regard. One element is the inspiration TRIPS provided for subsequent international treaties, which have in a number of cases confirmed or emulated or further developed rules that the TRIPS agreement, or solutions that the TRIPS agreement had found. One example for this is the evolution of the three-step test. As you know, this instrument originated in the Bern Convention in Article 9.2, where it had been conceived to cover exceptions from the reproduction right only. But this technique of having these three general elements as criteria for permissible exceptions was used in the TRIPS agreement not just for the copyright reproduction right, but for copyright exceptions generally, trademark exceptions, design exceptions, and patent exceptions, as you well know. So having established the three-step test as the instrument to test legitimate exceptions, this was also taken up subsequently in the WIPO Internet treaties. The World Copyright Treaty Article 10 and the WPPT in Article 16 use that formulation to describe the basis for legitimate exceptions in the context of these treaties. So here's a good example of how the progressive norm setting at the international level took into account this solution from the TRIPS agreement. Another example might be from the area of the relationship between trademarks and geographical indications. As you know, the TRIPS provisions in this regard are found in Articles 22 to 24 and have been the subject of quite some discussion during the negotiations, but also since then. They have also been the subject of a number of two dispute settlement cases, which aimed in particular at the question of the right balance between trademark and geographical indication. The result of these dispute settlement cases is a fine-tuned balance on how much one can privilege a geographical indication vis-a-vis a protected trademark. And this fine balance, I think, today represents the current international consensus in this regard. While there are many that want to give more protection to geographical indication systems at the multilateral level, the TRIPS provisions as interpreted by these dispute settlement cases represent this balance. And you can see that this is recognized in subsequent international treaties. When you look at the Geneva Act of the Lisbon Agreement, the recent revision of the Lisbon Agreement, as you know, where in Article 13, under safeguards for existing rights, that specific balance, so the possibility to have a certain well-circumscribed limitation of trademarks vis-à-vis subsequent GIs, is expressly recognized in Article 13.1. So these two examples are just there to highlight how subsequent international treaties picked up solutions and then sometimes formulations from the TRIPS agreement to incorporate them in their regulatory approach. Now, as regards subsequent FTAs and RTAs, you'll be aware that in most WTO agreements, notably the GATT and the GATS, the most favored nation principle, which normally ensures non-discrimination between different WTO members, provides for exceptions for RTAs. Under the GATT and the GATS, these exceptions allow deeper integration with individual trading partners without having to multilateralize the benefits agreed to in an FTA or an RTA. Notably, the TRIPS agreement does not provide for such a general exception. And while Jagdish Bhagwati coined the phrase of the spaghetti bowl, the WTO spaghetti bowl that was created by these RTA exceptions in the area of goods and services, Tony Taubman extended this metaphor in one of his articles, saying that in the case of intellectual property and the TRIPS agreement, the appropriate metaphor is more a lasagna dish, because additional obligations entered into in a bilateral treaty on intellectual property actually add layers to the TRIPS obligations of the signatories, because they are required to make these benefits available to nationals from all WTO members under the TRIPS MFN provision. Now, this has not stopped countries to enter into more and more FTAs since the entry into force of the TRIPS agreement. In fact, the work of my colleagues in a number of staff working papers, Raimundo Valdez and most recently Megan McGann, who you've heard earlier, have shown that not only does the number of RTAs rise, but fewer and fewer of those RTAs can now do without intellectual property rules. In other words, almost all of the FTAs and RTAs that are agreed in recent years have also chapters or provisions on intellectual property rights. Now, we know that bilaterals have sometimes been seen critically, and there's a lot of literature about additional obligations being entered into that go beyond the level of the TRIPS agreement. But the point I wanted to highlight here is that most of these, in fact, over 60%, and this is data from 2014, so it has risen further since, a large majority of these agreements actually situate themselves well within the existing international IP system. So many of those reaffirm the TRIPS agreement or even provide that the TRIPS agreement would have precedence over the RTA chapter on IP, thereby deferring in large part to the existing international system in this regard. And I think this is quite noteworthy. I want to support this with a few examples. So here is an example from the Chorus FTA, the FTA signed between the Republic of Korea and the United States of America. In its Article 22.4 here, the signatories agreed non-violation complaints should in principle also be intellectual property chapter of this agreement, footnote that you can see here on the screen, they expressly defer to the moratorium that members have agreed in the WTO, and agree that as long as members agree on this moratorium, neither party will invoke this subparagraph, the non-violation complaints, for intellectual property rights. So here you have an example of specific deference to the multilateral system and its institutions before any such provisions in the bilateral shall come into effect. Another example is from a more recent RTA, the Regional Comprehensive Economic Partnership Agreement, RCEP, which was signed very recently. Here you can see quite expressly that the signatories, the numerous signatories of this agreement, consider that the TRIPS agreement shall prevail over interpretations of the IP chapter in case there is any inconsistency. So there is an active subordination in this regard in terms of interpretation, which means that the signatories expressly see this chapter as building on and not contravening the TRIPS agreement. Similarly, in Article 11.8 of the chapter on IP, you can see that the parties reaffirm the Doha Declaration on the TRIPS agreement and public health from 2001. So the reaffirmation of the flexibilities that was expressed in this declaration is also incorporated in the agreement. So you can see, and in fact, in a number of other articles in Chapter 11 of RCEP, you can see that they track the language of the TRIPS agreement in great detail. So these two examples highlight quite a large number, are only two examples for many of these bilateral agreements, which see themselves as being situated and supported by the multilateral IP system that is created by TRIPS and WIPO conventions and agreements. So in this regard, I want to highlight Francis Gurry when he accepted his re-election as a Director General of WIPO. He listed the challenges that the multilateral IP system was facing, and he included therein the reality of a multi-speed and multi-tiered world in which multilateralism, while being the highest expression of inclusiveness and legitimacy, is nevertheless the slowest solution. So this, of course, recognizes the fact that the multiplication of bilateral treaties was in large part the reflection that it was often quicker and less controversial to reach agreement with just two partners, while it was clear that the multilateral solution would be more inclusive and thus, to a certain extent, more legitimate. However, I hope I've shown with this little presentation here that the system that is created by this multiplying international instrument remains, by and large, coherent. You can see that the solutions found in the TRIPS agreement and the experiences from their application have informed subsequent international treaties and are taken up both in spirit and sometimes in formulation. The majority of the bilateral and regional agreements on IP, they expressly recognize the multilateral IP system, and they situate themselves in its context by reaffirming TRIPS or recognizing its precedents. And the TRIPS regulatory framework, thereby, many of its principles, is now confirmed and required by multiple legal instruments. So not just by the TRIPS agreement, but by the reaffirmation and the recognition in other treaties also becomes an obligation thereunder. So this means that the solutions found in the TRIPS agreement 25 years ago are now woven into the very fabric of the international IP system. Its principles and objectives, its minimum standards, as well as its central idea of balance, therefore now forms the basis on which new and future IP rules will develop. So I thank you for your attention, and I hope you've enjoyed this short presentation. So this presentation on the relationship of TRIPS to FTAs and RTAs and to subsequent international treaties brings us to the end of our morning session. I hope you've enjoyed seeing almost all the members of the TRIPS division this morning, giving their insights on individual parts of their work. I would invite now my colleagues to show themselves on the screen so that we can maybe have a full view of us when we look at what questions might have been posed to us in the course of this morning. There are a number of channels through which questions could be posed. So we had I think Josefita, who has tried to keep track of this. I don't know whether we are all available. I don't know whether Tony is also here to join us. One upshot of using recorded presentation means that we are almost perfectly on time, which is, I'm sure, appreciated by the viewers and the presenters. So let's see whether there are any questions that we might be able to answer. Josefita, would you like to take the floor?
Thank you, Wolf. Let us go to the first question. Why are there members that have not yet ratified the protocol amending the TRIPS agreement?
So are there more questions, or
yes, there are more questions. Shall we? But they are on different topics. So if you like, we can start with the one on the protocol.
Yeah. I think that's one for Roger, if you would like to try and take that, or anybody else.
Yes, thank you very much, Wolf. And I'll give you a sort of brief answer to this. I think it's always a bit of guessing, of course, to respond to such a question. But of course, the for domestic procedures to be completed, they require sort of thorough understanding, including the distinction between acceptance and implementation, and also the coordination with different sort of government departments. So that, I think, is a continuing challenge for those who are still to accept the amendment. And we've on various occasions, we have provided assistance to those members to help actually getting things up and running. Of course, I think we also have to acknowledge that the process may be delayed in a number of countries because of other pressing policy needs, which have priority over accepting the amendment. So that, I think, is a reality in some countries. And it's something not to be forgotten. Sometimes this process may sort of join a broader sort of legislative package, which may also explain in some cases a delay. Now, all of this, to my knowledge, just to conclude, there's nothing really which signals that countries have sort of substantive problems with the acceptance of the amendment as such. I think it's more sort of on the procedural side where issues are sometimes a bit slow and where we keep reminding sort of members as necessary that this is still something pending. So thanks.
Thank you. So yes. Anybody else who would like to add something to this? Otherwise,
I would just add that you know, we are in touch with, as Roger's mentioned, with a wide range of members, and I really think that the main constraint was an assumption that the political agreement that is behind the amendment sort of carried through automatically to legal confirmation, and the dialogue we've had with the members concerned really does emphasise that it really is just a matter of getting on top of the domestic procedures. and as Roger's mentioned, that other things find their way to the top of the foreign minister's in tray, but we've never heard anyone say that there's an issue with it, there's a difficulty with it. It's more been a practical delay rather than a fundamental problem.
Thanks. Yes, I think highlighting the primacy of national law, of course, to give effect to obligations or even amendments at the international level. Josefita, any more questions?
Yes, thank you, Wolf. I think this is a question for Hanu, and it says, with the situation in the appellate body, are members still bringing disputes that relate to the TRIPS agreement? Thank you.
I don't think it has affected the rate of disputes coming in. The most recent report that was issued concerned Saudi Arabia's IP regime, and the panel report was appealed, but of course now there's this problem, what happens next, as we don't have the appellate body. There are some more recent cases that are now pending, and the panel, one panel report is coming in the foreseeable future, and then some other cases pending. So I think that the WTO dispute settlement system will continue to serve its function. The issue about the appellate body is separate from that.
Yes, indeed. It seems that the cases are not abating just because the appellate body is currently not in action. Anybody else, or otherwise we can ask Josefita whether we have any more questions. Josefita?
Okay, so this question is for Megan. Is there any coordination of TRIPS-related capacity building activities amongst members reporting to the TRIPS Council? Thank you.
Megan, would you like to take this?
Yeah, sure. Thanks, Josefita, and many thanks for this question. And indeed, I mean, as mentioned in the presentation that I gave, the technical assistance that the WTO delivers is demand-driven. So part of what this means in designing the programs and delivering the activities is that we work very closely with the member who has requested the activity to craft the program, to make sure that we're meeting their needs, make sure that the program responds to the kind of technical details that they're looking for. So yes, absolutely, we work very closely with members in the design and delivery of technical assistance. Thank you.
It sounded as if it was also a question about coordinating among the members that give technical assistance. I don't know whether that is right. And there, maybe it's worth highlighting that we know, of course, sometimes that there are efforts to coordinate. I think there are efforts among their IP attaches of the developed countries to coordinate their technical assistance to some extent. We haven't had detailed reports in this regard, but this is of course indeed a very good question, which we should invite the members to address in that regard. So I would invite whoever asked that question to ask the members themselves how far these efforts have developed. Anybody else, or any more questions?
I would just note as a footnote to that discussion that particularly for LDCs there was quite a structured process of identifying needs and priorities conducted in the TRIPS Council. This is specifically for least developed countries. I think it did illustrate, and it was followed up with a number of more informal workshops to enable that kind of coordination to take place. And I think that was reasonably successful, but of course, like all of these things, it's a matter of maintaining the effort. There was a study, in fact, commissioned by the Swedish government, was supported by the Swedish government, that helped to draw together this material. But that is now out of date, and I think the question is a good prompt, a good reminder that that coordination process is important. We do know that there's a great deal still of resources available from bilateral partners, from regional bodies, from multilateral organizations, and one of the challenges for developing countries, and for LDCs in particular, is indeed coordinating the different flows of support and technical assistance. So I think there's a really important point behind that question, and something that indeed it's important for us to follow up.
Thank you. I think, should we take one last question? It's 1:20, and I think we're ready to break. Is there any more? Do you have one more for us, Josefina?
I think we have one more, Wolf. It would be for Xiaoping regarding Article 66.2 of the TRIPS agreement. The question is, will the establishment of focal points in least developed countries and donor countries help operationalize technology transfer? And which industries are the most promising? Thank you.
Thank you. I think it's two questions. One is about a contact point. Contact point actually is a proposal made by the LDC in the context of the workshop I just mentioned in my presentation. So as I mentioned, this is just a proposal they made in the workshop and also the TRIPS Council's discussion. So once again, this proposal is up to members' discussion and also decision. Second question is about, I'm sorry, reminding me the second one.
No problem, Xiaoping. It's about which industries would be the promising for tech transfer.
Actually, it's an excellent question. As also I mentioned in my presentation, I think the Secretariat, we are committed helping the LDC understand the reports and assess their priority needs. So this is exactly, when we prepare the next year, the workshop, we work very, very closely with the LDC group, and we try to identify the area of priority and for the technology development. So I can see, according to the last year's workshop and current, WTO work on this topic, and also the TRIPS Council discussion, and plus the developed countries' annual reports, we actually identify 4 areas maybe now is the priority for the LDC. One is the technology transfer in the area of health-related technology, environmental technology, and also the green technology. And plus, I think information and communication technologies. So these 4 areas is we have work very closely with the LDC group, identified. But as I said, we definitely the Secretariat's role is help the at least developed country members and plus reporting country members to make this the implementation, in a more effective way. Thank you very much for this very, very good question. Thank you.
Thank you very much. I think it's now 1:23, and we beg the indulgence of our viewers to have stayed with us for so long. This is the end of the morning session of the virtual symposium of celebrating 25 years of the TRIPS agreement. Thank you for staying with us. We will now take a break until 3 p.m. Geneva time, when the afternoon session will commence with theme 2. Theme 2 will look at the current and future impact of TRIPS on national IP systems. And we are fortunate to have a number of inspiring TRIPS experts that will share with us their thoughts on the areas of TRIPS and development, the digital landscape, and new technology and innovation policy, and their relevance and challenges for the international IP system. So please come back at 3 p.m. If you're following this event on YouTube, please note that the link for the afternoon session is a separate link that you can find on the YouTube account of the WTO Conference Services. And I thank my colleagues and all the other speakers of this morning for having contributed. And with that, I wish you indeed a good lunch break if you are in this time zone. Thank you very much and see you at 3 p.m.